Court calls the case of the People versus Benjamin Detlefs. And
Good morning, Your Honor. I'm Sept for the people.
Brian Bowling on behalf of Mr. Detlefs, Your Honor. Benjamin, can you state your name for the record, please?
Yes, I can. Benjamin David Detlefs, Your Honor.
Morning, Judge.
good morning.
We received a report from the Forensic Center via Ms. Feltis this morning, Your Honor, that is deeming him to be competent.
I had just gotten it yesterday, so I forwarded it this morning to the court in defense.
So I would stipulate to that report, Your Honor.
People would also stipulate, Your Honor, we have no additional evidence.
All right. Based upon a review of that report, the court would find that the defendant is competent to stand trial. Would specifically find that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is competent. I need an, do you have an order, sir? Or
Oh, yes.
you don't have it yet?
Not yet. You will have it shortly, Judge. Can we reset it for a PCC, please?
Yes, sir. Set a probable cause conference. What date are we on? We're 2 weeks out. 25th. Sorry. Probable cause conference September 25th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue. Court does call the case of the People versus Shannon Roberson.
Good morning, Your Honor. Laura Rosenberg on behalf of the people.
Morning.
An Assistant Public Defender, Natalie Pate, with and on behalf of Mr. Roberson, who appears via Zoom from the MDOC. Sir, can you please unmute and state your name for the record?
Shannon Roberson.
Thank you, Your Honor. I did speak to the people regarding this and had submitted a stipulation to adjourn to the court. I do have an in-person meeting scheduled with Mr. Roberson for next Friday, September 19th in the afternoon at the Jackson Prison. So I would ask for an adjournment sometime after that date.
You ready by the 25th?
I think it might be a little safer, Your Honor, for the week after. His earliest out date's the 23rd.
30th to be 5 days after. I have October 2nd.
October 2nd would be great, Your Honor. Thank you.
Probable cause conference will be adjourned without objection to October 2nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. I'll see you next week, Mr. Robertson.
Oh, you say skip. You put it on there. Sorry, I don't have the 2nd because of the Tuesday, so it had to be October 9th. October
Your Honor.
9th.
Thank you, Your Honor.
On there. I got you. Court does call the case of the People versus Cassie Colley.
Foley. Morning, Your Honor.
People.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Colley. Ms. Colley, state your name for the record. We didn't already.
Cassie Coley.
Foley.
Your Honor, we should have a plea form in front of you with a signed advice of rights form.
All right, I have a plea form that indicates that the defendant would be pleading guilty to retail fraud second degree, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. She agrees to pay restitution as ordered. That's the entire understanding of the.
That is our understanding as well, Your Honor.
All right, ma'am, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again, please.
Cassie Lynn Coley.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become your maximum fine. You understand that?
Yes, Your Honor.
And they already did.
I need that one shut. Do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form or gave permission to sign that after going through it with your attorney?
Yes, Your Honor.
Do you have any questions regarding those rights?
No, Your Honor.
You understand that you're giving up your trial rights as contained in paragraph 5, as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily and of your own free will,
Yes, Your Honor.
and also because you believe that you're guilty of this offense?
Yes, Your Honor.
December 16, 2020, at the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Meyer store that makes you think that you're guilty?
I took some items that I did not pay for, Your Honor.
All right, and you tried to walk out of the store without paying for them?
Yes, Your Honor.
Store was open to the public at the time?
Pardon me?
Was the store open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to take that property, did you?
No, Your Honor.
And the property you took was property that was offered for sale by Meyer?
Yes, Your Honor.
All right, is the second based upon value?
Yes,
All right. Was the aggregate amount or the total amount of the property that you took, was that in excess of $200?
Yes, Your Honor.
Ma'am, if I accept your plea, I have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, that the court would no longer be bound by any sentence evaluation or recommendation in the case. You understand that?
Yes, Your Honor.
You also would not be permitted to withdraw your plea. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, sir.
no, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes,
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be,
September 24th at 9 a.m.
so we can't do the
October
20,
8th.
because I need 2 weeks if she's gonna be by Zoom. October 8th,
Yes.
October 8th, 2025, 9 a.m. That's before me. Bound will continue.
I do have one thing, Your Honor. Miss Foley is
Go
in,
ahead, Parity.
thank you, Lenawee County.
Really? Yeah.
There were warrants issued because I believe failure to appears. They submitted her social worker from Lenawee County PD submitted warrant recalls. Your Honor set these dates but kept the warrants in place. She's has approval to go to Bear River, but these are holding her up. So there's this case, and then there's 2 misdemeanors scheduled for the 17th before Your Honor, where there's still warrants. So I'm asking that the court recall the warrant in this case, or all 3 if possible.
She will be in Lenawee. The entire,
Well, she's in Lenawee, but she has a release to treatment there. So as soon as these warrants are resolved, she'll be released to Bear River from Lenawee.
in this case, it's before me. I will cancel the warrant. I'll reset her bond at a personal recognizance. $5,000 personal recognizance bond. In the other matters, I suggested you communicate with Ann, and
Okay,
we'll see what we can do on that.
thank you.
Thank you. Thank you, ma'am.
Thank you.
Court does call the case of the People versus Jennifer Lindsley.
Morning, Your Honor. Raymond Cook.
Good morning, Assistant Public Defender Lauren Perny on behalf of Miss Lindsay. Miss Lindsay, please state your name for the record.
Jennifer Lindsay.
Wow, she was right on time. Your Honor, we're asking for an exam date, please.
Discovery is complete.
Yes, my knowledge.
And what facility? She's at Huron Valley, so we could do, I think. If she said here, that'd be enough time for her. Would the people have their witnesses available September 30th?
Yes, Your Honor.
Preliminary examination in person will be set for September 30th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you.
Thank you.
We'll be in touch with Ms. Lindsay.
Thank you.
Court does call. Thank you. Court calls the case People versus Terry Probst.
Yes, sir.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Probst, who appears via Zoom from the Monroe County Jail. Sir, can you please state your name for the court?
Terry Allen Probst.
Your Honor, I have followed the instructions on the Monroe County Jail's instructions to schedule a video visit with my client. I do have an online account created in the system. I do have the facility added. I do have my client added. It is pending approval. So I'm asking for an adjournment. If that is not approved by sometime early next week, I plan on maybe just showing up there in person and seeing what has to happen.
The end, what? What are you gonna-
Asked if I can see them. They might be fine in person. I don't know.
Okay, how long, sir, how long do you, do you have a release date, I guess?
No, Your Honor, right now I'm supposed to go to court on the 15th, which is Monday.
Got it. Okay. Well, why don't I do this? Why don't I set it for the 9th, like the last one? If he gets out, then he can appear on that day. All right.
That sounds great, Your Honor. Thank you.
Probable cause conference will be set October 9th, 2025, 9 a.m. Bond continue.
Thank you. Thank you, Mr. Probst. I'll talk to you one way or another.
Yes,
There
ma'am.
was a bench warrant for his failure to appear.
Yes, sir.
That is-
Your Honor, I was in court. I was in here at the time of that bench warrant was issued.
Got it. What I'll do on that is I'll cancel the bench warrant and reinstate his previous bond.
Thank you very much, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the People versus Ardeen Henderson.
Brian Bowling on behalf of Ms. Henderson. Ardeen, can you state your name for the record, please?
Arlene Henderson.
Judge, just for the record, I did meet with Ms. Henderson via Zoom from the Wayne County Jail yesterday. I'm asking for an adjournment so she can continue to work with our AIM division and we can look into further possible resolution of this case. She does have a hearing in Wayne County tomorrow, Your Honor, but she did not know what would happen with that case. So, and I don't think she's going anywhere for the foreseeable future.
All right. You want the 30th or the 9th?
Let's do the 30th.
Probable cause conference, September 30th, 2025, 9 a.m. Bond continued.
Thanks, Judge.
Court does call the cases of the People versus Ronald Sims.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Sims. Mr. Sims, state your name for the record, please.
Ronald Sims.
So, Your Honor, there are 3 cases before you.
There are.
We are asking for exams in all 3. I will note for the record, because I know what question you're gonna ask. 2 of the cases we do not have media discovery on. I've spoken about this with Mr. Sims at length. He would like to set them for exam, knowing that he would not get an adjournment if we do not have it by the exam date.
Is that really what you want to do, sir?
Yes, Your Honor. We'll do that. We just brought to my attention that it- something, or we can do that after, later, the next court date.
Okay.
Yes,
Which 2 do not have media on?
The, I don't know the case numbers off the top of my head.
Okay, give me charges.
Largely from a vehicle, we have media on, the other 2 we do not.
So the B&E vehicle you do not have or do?
Okay, in the case ending in 5717, we do.
5717 you have.
Yes. The other two we did not.
All right. Fair enough. People have their witnesses available the 25th. So 12 days out, so let's see. Well, what's my day? 23rd. I guess I should say it's September 23rd, which you have people. Council, 23rd. Will that preliminary examination in person will be set for September 23rd, 2025, 9 a.m. before Judge Barr on all three matters. Bond will continue. Court calls the case of the people versus Brandon Bellotti.
Ready.
And Lizette on behalf of the people, Your Honor.
Good morning, Your Honor. Joe Simon on behalf of Mr. Bellotti.
Her name?
Brandon Bellotti. Requesting a preliminary exam, Your Honor.
Discovery is complete.
It is, actually. It just got complete, Your Honor. It just happened.
Sounded like a shock.
Well, it's recency, Your Honor. Recency.
Would the people have their witnesses on the 23rd?
We'll do our best, Your Honor. Your Honor, if I could ask the court to amend complete, the police report number that's listed is incorrect.
Hang on 1 second. Preliminary examination in this matter will be set for September 23rd, 2025, 9 a.m. before Judge Freshour. His bond will continue and you needed the complaint amended to.
Your Honor, the police report number is AAPD 25-37347 rather than 437.
Three 7347 is what it should read.
Correct, Your Honor.
Right.
Thank you, Your Honor.
Bond continues. Thank you. Court does call the case people versus Stephen Grisbeck.
Assistant Public Defender Chelsea Vergils with and on behalf of Stephen Grisbeck on cases ending in 1354 and 5176.
Morning, Your Honor. Sam Bernstein on behalf of Mr. Grisbeck on 11.
What are we doing?
Stephen Grisbeck.
Your Honor, we're asking to adjourn, I believe, on all cases. We're trying to see if we can reach a global resolution. I would also ask the court to consider a release to treatment. I believe he already has that on 1354. We're asking for that as well on 5176.
I just heard bells while you were speaking. You want release to treatment. If you prepare an order, should be stipulated to send it to me. I'll sign off on it.
Okay, thank you, Your Honor.
All right. And what are we doing on yours?
Likewise, Your Honor, asking for an adjournment to try.
Okay, timing wise, you're trying to do a global resolution, but there's other cases in circuit. When are those?
No, there's no other case in circuit, Your Honor.
It's just these.
Yes, Your Honor.
He is currently serving a sentence, but a motion should be forthcoming regarding the request for release to treatment on that.
The 30th, will that work?
Yes, Your Honor.
Matters will be adjourned to September 30th. 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the people versus Philip, is it DiPatrizio?
DiPatrizio, Your Honor.
DiPatrizio, is that the right side?
what I thought.
Okay.
And then we have-
Your Honor, good morning. Joe Simon on behalf of the defendant. State your name again.
Philip T. Patrizio.
Thank you.
And Your Honor, we're asking this matter be set for exam as well.
Discovery is completed.
Yes.
People have their witnesses available the 23rd.
We'll do our best, Your Honor.
Preliminary examination in this matter will be set September 23rd, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you.
You can go home. All right, we'll see.
Court does call the cases of the people versus Kevin Davis.
Morning, may it please the court, George Lyons on behalf of Mr. Davis in both files. And respectfully, my client, Your Honor, after having discussed this with him and the people will be waiving his preliminary examination, Your Honor.
Yeah, waiving on both
Yes,
cases.
on both files, Your Honor. He knows and understands his right to a preliminary examination. He also understands the burden that the people have that by waiving this, the matter will be bound over the circuit court for ultimate resolution. He's affixing his signature to the waiver on both files.
Sir, is all of that correct?
Yes, sir.
You understand that the preliminary examination which your counsel speaks about you will not have, and this matter will be sent to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination have been waived in both matters. Defendant is bound over to circuit court on both counts.
Your Honor, before the fixes his signature to the bond, may I address or ask the court to reconsider the bond, my application for bond modification I made last time? Respectfully ask the court to consider something that includes a tether to his parents' home in Albion, Michigan, where he was raised. And
Pardon?
may the court consider a tether to his parents' home in Albion, where he's from. Mom and dad are here, Your Honor. The allegations here took place some time ago when my client was a teacher here, Your Honor, I believe 8 years ago. 6.5 years ago. Your Honor, the people's objection is that he was living in Florida. Well, he doesn't live there now, Your Honor. He respectfully living in Michigan until this matter is resolved. He is a Michigander, Your Honor, so perhaps not a Michigan's fan.
Response.
I believe his bond is appropriate as set. Nothing has changed since the last time this motion was made. He was extradited from Florida. It is correct that these allegations took place some time ago, but I have concerns that there are two separate victims. Both took place while they were minor students, and the defendant was their coach.
May I respond to simply say my client didn't?
I thought I already ruled on this, but go ahead.
My client didn't. The court did, Your Honor. But my client did not abscond to Florida. He moved there to take it for his wife had a job there, and he was down there. I think actually applying to the police force down there. So this isn't an absconding case where he and his family actually moved to Florida. May I approach with the signed waivers?
Anything else from either side? No. It sounds like the same argument, so it's going to be the same for bond reduction is denied. Thank you. As to the circuit court arraignment counsel.
Yes, Your Honor.
You waive formal reading of the information.
Yes, we do, Your Honor. He'll be standing mute.
Defendant having waived formal reading, standing mute as to all 4 counts. Court will enter a not guilty plea. Pretrial in these matters will be set for
September 22nd at 1:30.
September 22nd, 2025, 1:30 before Judge Hammoud.
Thank you, Your Honor.
Bond will continue. Thank you.
Your Honor, may I approach and sign the information?
Yes, you may. Court calls the case People versus Lawrence Pack.
Ready, Your Honor. Trevor Mabel for the people.
Lawrence, how would you? And Joe Simon on behalf of Mr. Peck. Didn't hear that.
Lawrence Peck.
Thank you.
Your Honor, we adjourned this once before to allow another charge to ripen, which it has, which is an OWI second before Your Honor next week. They arise out of the same incident. My client is now, I've informed the people, he's interested in entering the 14A sobriety court, and I'm arranging for him to be screened for that process. I'm asking the court to adjourn this probable cause conference probably around 3 weeks, if the court would entertain that.
Weeks. I had the 30th of October.
Just to be safe, it's probably the latter date is the.
Any objection from the people? We adjourned October 9th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Court does call the case People versus Anthony Williams. In case. How many AG cases, Joe?
Just two. Good morning, Your Honor. Assistant AG Clarissa Williams.
Assistant Public Defender Chelsea Vergil is with and on behalf of Anthony Williams. Please state your name.
Anthony Williams.
Your Honor, I'm asking for, if possible, 1 week adjournment. I did receive an offer from the Attorney General yesterday after I was speaking with Mr. Williams. So just to keep things moving along, asking for a very short adjournment.
1 week would be the 18th. That objection, probable cause conference, September 18th, 2025, 9 a.m. Bond continued. Thank you.
Thank you.
Court calls case People versus Brandon Kelly.
Assistant Public Defender Chelsea Vergil is with and on behalf of Brandon Kelly. Mr. Kelly, can you unmute and state your name?
Yeah. Yeah, let me see. I got it. All right, Brandon Kelly.
Your Honor, we're asking to adjourn this for media, and may I address bond?
Probable cause conference will be adjourned to September 25th. Yes, that's about.
We are asking the court to consider a personal bond or a very low cash bond. Mr. Kelly has a plan for, if he's released, he would stay with his parents. He also would be in treatment with CMH. He does not have a criminal history, understands his bond conditions, and I think it would be beneficial to him to get that mental health treatment out of custody. He has been in custody for 70 days now. So
Only on this case?
he had another misdemeanor. My understanding was that the bond was set at $100 on that just to get time served.
He does have another case. I'm sorry, I don't know if the time was finished. It's completed there.
I'm finished. Thank you.
So Your Honor, we do believe that Mr. Kelly still is in a danger. With Mr. Kelly, while it is true that he has a CMH plan, it's the result of being petitioned while he was in jail. That petition last month because he was threatened to kill a jail staff member, to injure jail staff. He refused to take any medication. Your Honor, it was indicated that I checked the register of actions. He just had his hearing 2 weeks ago. And at that hearing, he was found to be a person in need of treatment, that he, one, is a danger to others, and also doesn't necessarily recognize the amount of treatment that he needs. And
That treatment is completed.
Okay, thank you for interrupting. Go ahead, Mr.
So Your Honor, I know in the petition that it did indicate that the petitioner was recommending that the jail be able to give Mr. Kelly shots of antipsychotic medication since he would not take medication. So while I'm sure in the last 2 weeks, he might be benefiting from that medicine, I feel about whether he will continue that medication once he's released. The allegations here, I think, indicate a danger to the public. If there had been some ongoing treatment that he seemed cooperative with, I would feel different. But in this case, he's accused of punching a Target employee in the face where he busted his lip by using a watch wrapped around his knuckles as a makeshift metal knuckles. I would also note that in the other case, he was accused of following a stranger to a library bathroom. When that individual turned around to find out why Mr. Kelly had followed into the stall. Mr. Kelly asked him what he's looking at, and then he punched that individual in the face, giving him a black eye. So with such a short amount of treatment, given that he's had a history of non-compliance, I don't think at this time that it's safe for the public.
Anything else?
I would just say we're not denying that he has had, mental health struggles and he is going to get help with that. I think that the circuit court order for assisted outpatient treatment is a determination that it is appropriate for him to be getting outpatient treatment rather than being hospitalized or some more restrictive alternative. I also think with a supportive family, he would do well in that environment. So we still ask the court to consider that.
Motion for bond reductions denied. Bond will continue. Thank you.
When's the next court date?
25th.
Thank you, Your Honor.
Court calls case People versus Imbaye. Yeah.
Good morning, Your Honor. Assistant Public Defender Gabby Leba on behalf of Mr. Ngai, which I believe is the correct pronunciation. Yeah, bye, Baba. Mr. Ngai, could you please state your name, sir?
My name is Baba.
And good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
And Your Honor,
what are we doing?
And Your Honor, I do have a green sheet. We would be requesting an adjournment. I would ask if the court could provide 60 days. I realized that was a long shot, Your Honor.
Oh, I was going to listen to your reason for it and then tell you no.
I would like the court to hear, I realize it's long, but I do want the court to hear my reasoning, which is Mr. Ngai has a significant amount of arrearages. We do have an offer that will be contingent on him paying off those arrearages very significantly to around the $13,000 amount. And he believes he can do that if he's given that 60-day adjournment.
Is it a misdemeanor resolution?
The offer would be for a delayed sentence at circuit court.
So wouldn't it be wise to waive it to circuit court, see if he does it, and then they can? That would seem to me to be a way to handle it.
I don't disagree.
It doesn't matter to me.
I don't disagree.
I'll keep this one too, but
I don't disagree, Your Honor. I did email Ms. Williams to ask if she would agree to hold that offer open at circuit court, but in the absence of a reply, I felt it was best to request the adjournment.
Madam Attorney General.
Oh, well, I mean, it's like Judge Simpson said, those offers were contingent upon you waiving the preliminary exam. So either way, I think at some point you would have to do that. I mean, of course, you can wait. And if you have it at that point, then we can waive it and go and finish the process. But again, they were contingent upon you waiving the preliminary exam.
So if I understand, that offer would be held open if Mr. Ngai were to waive today.
If it's contingent upon, it seems to me it would have to.
We do this all the time. Yes, it would be.
Yes, you do.
Thank you, Madam Attorney General. Would you be okay with completing this issue at circuit court? So you would skip the exam. Your Honor,
Your other case, we adjourned out 1 week, correct, Madam Attorney General?
That is correct.
All right, let's just do this so that they can have a full conversation.
Thank you, Your Honor.
Probable cause conference will be adjourned to September 18th, 2025, 9 a.m. Bond continue. Thank you. I think that's your last case, isn't it?
It is.
Okay. All right, have a good day.
You too.
Court calls the case, People versus Amanda Corwin.
People. And Your Honor, Joe Simon standing in for Ms. Corwin. She's making her way to the podium. Amanda.
Standing in for.
Well, I'll explain in just a second.
Okay.
State your name, Amanda.
Amanda Corwin.
Your Honor, I appeared as a courtesy from a professional referral for Mrs. Corwin at her arraignment. I believe that
you did a courtesy?
Yes, I did.
Oh, okay.
It was really kind of him.
And I believe
shocking. No, go ahead.
At the time, I believed I would be filing an appearance of counsel, but I'm not. Ms. Corwin is seeking other counsel, and I told her I would assist her to ask for an adjournment for that to happen.
But fabulous.
Okay.
Can give him that.
How much time would it take you to get an attorney?
You want 2 weeks?
Can I just have 2 weeks? By then I should have most of
The 25th?
Yeah, that should work.
All right. Any objection from people?
No, Your Honor.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. And you always do reasonable things.
Well, thank you, Your
Thank you,
Honor.
sir.
All right. Look, and you're all set.
Thank you.
Court does call the case, People versus Moses Steger.
Trevor Maysville for the people, Your Honor.
Assistant Public Defender Virgils with and on behalf of Moses Steger. Please state your name.
Moses Steger.
Thank you.
Your Honor, on the case that I am on, I am asking to adjourn.
Hello,
Mr. Killawald approaches to do something else on his cases.
Kilowald on 25F2, 1193, and
1351.
correct. Judge, I met with this young man last night at the jail. On my two cases, he wants to proceed to preliminary exam. What I have, Judge, I have to be in Detroit on the date you've been giving for the 23rd. Is it possible to
Put it down 1 second. On your case, you're looking for an adjournment. That's on 1274.
Thank you, Your Honor.
Is that correct?
Oh, yes, yes.
So on that matter, I'll adjourn the probable cause conference to September 25th, 2025, 9 a.m. Bound continue. And then here's the reference to your preliminary examinations. All discovery is complete.
Yes, Your Honor. Wondering if we could go past the 23rd.
Yes, I can set it for the 30th.
I'm sorry?
I can set it for the 30th.
That would be fine, Judge.
Your Honor, I'm sorry to make this difficult. Is it possible to get mine adjourned after that preliminary exam?
You have that file. I give it to you. I'm gonna change your mind. So let me know.
Oh, this for me?
So you want the 30th, Mr. Hill?
If it's possible, Judge.
It's always possible. So
You're very considerate, Judge.
preliminary examination will be set in the two matters for September 30th, 2025, 9 a.m. That's before me at noon.
Yeah. Okay. Thanks, Judge. I'm gonna come down with the videos.
And then you wish to have a date after that. Is that correct?
Yes, please.
Bond on that these matters will continue on the case ending in 1274. I will set the probable cause conference to the next date available after 30th to October 9th, 2025, 9 a.m.
Thanks, Judge.
Thank you. Court calls the case People versus Devontae McFarland.
People.
Oh, he's on Zoom. Good morning, I'm Rob Jekyll on behalf of Mr. McFarland. Would you?
McFarland, can you unmute and state your name? Yep, we can hear you. What's your name?
McFarland, can you state your name?
McFarland.
Thank you.
Judge, may we approach very, very briefly?
DeJounte McFarland.
Yes.
For the bench conference, Judge, at this time, As I explained to my client, I would be asking for an adjournment. We're waiting for the forensic center report. It's my understanding you're going to adjourn this till October 9th.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continued.
Thank you. Mr. McFarland, I'll come down and see you again, okay?
Yes, sir. Thank you.
Thank you. Court calls the case, People versus Anthony Alexander.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Alexander.
Anthony Alexander. Thank you.
We're asking for an adjournment, Your Honor.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case of the People versus Stephen Bauer.
Morning, Your Honor. May it please this honorable court, David Burgess on behalf of Stephen Bauer.
Thank you. What are we doing?
Your Honor, today's date time set for adjourned probable cause conference. My client is executing a waiver of examination, Your Honor.
Sir, you're going to waive your right to have a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on all 8 counts.
Your Honor, as to the arraignment on the information, waive formal reading, stand muted to the charges contained.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 25th at 1:30, Judge Slay.
September 25th, 2025, 1:30 before Judge Slay.
Thank you.
Thank you. Bond continued. Man, that one I can find. Court calls the case People versus Philip Carrick.
And then on behalf of the people.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Carrick.
Philip Carrick.
Your Honor, we're asking for an adjournment. We're still waiting some discovery.
And you're in the discovery, you received it, it's with the OIC, he's off for a few days, so we should get it relatively soon, his medical records and other media and photos. So it should be incoming.
Probable cause conference September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case People versus Anton Brooks.
And for the others, for the people.
Good morning, Your Honor. Brandon Bird on behalf of Anton Brooks. Anton Brooks.
And Assistant Public Defender Ben Dunaway on behalf of Mr. Brooks on the case ending in 1261. Your Honor, we're demanding on the 1261 case.
Pardon?
We're demanding exam on the 1261 case.
And we're respectfully requesting exam.
No, I appreciate no. So he'll get his. You keep up with your demands. No. Discovery on both of these matters is complete.
Yes, Your Honor.
As far as I know, Your Honor, I was told that there is no body cam in this. I just wanted to make sure that's correct.
There's no video in the case of Mr. Bird. That is an RNO that it wasn't on the street. It was actually here at the service center in between exams. Yes, Your Honor. So there was nobody.
Okay.
Oh, and I have it that they pulled him over for tent. For his tent on
the hallway?
For the RNO?
Correct.
Well, Mr. Bird's on the. Hold on a second.
Sorry.
Denowith is on the RNO.
Oh,
And
sorry, I thought you were on RNO.
So, do you know when you could provide me that body cam, please?
2 weeks ago. You say what? You went through this 2 weeks ago.
Don't have any.
So they're indicating there is no media.
Respectfully, we'd like to, respectfully request exam, yeah.
Okay, would people have their witnesses available the 23rd?
Yes, Your Honor.
Preliminary examination in person in these matters, September 23rd, 2025, 9 a.m. before Judge Fresh Hour in both matters. Bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Demetrius Job.
Good morning, Your Honor. Please, Honorable Court, David Burgess, on behalf of Demetrius Joe.
All right, what are your name, sir?
Demetrius Joe.
Thank you. What are we doing?
We're setting a preliminary exam on this matter.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 23rd. Preliminary examination, September 23rd, 2025, 9 a.m. That is before Judge Barr.
Thank you, Your Honor.
Thank you. Bond continue.
Me too.
Court does call the case of the people versus Quentin Coleman Ebersol.
Then on behalf of the people,
Your Honor, Joe Simon on behalf of Mr. Coleman Ebersol. State your name, Quentin.
Quentin Coleman Eversole.
Your Honor, in this case, the people and I are engaged in some negotiations. There's also a little bit of continuing discovery. Ms. Zenda is going to be leaving town next week, but she and I have pledged.
What?
Yeah, that's what I hear.
Oh.
Do I have a new last name I need to learn? Because I keep tripping over Lonnie.
Never
Phelps.
know till they get back. We will.
Yeah.
We won't. Sweet. Go ahead. It's been hard, Ashley. I'm sorry.
In any event, we have pledged to try to make a resolution actually before she goes. And we're asking the court because part of that resolution may involve possibly a stipulation as to bond. So asking the court if it would adjourn the matter 1 week, and we will not address bond today in consideration of those discussions.
But hold it. Zenda won't be here next Thursday.
Right, but we're hoping that we will have our matters resolved by when she leaves so that somebody else can just stand in her stead.
Leaving Tuesday.
She told me.
I'm sad.
Me too.
I'm happy for her. But I'm sad. Okay, that makes me feel better. All right. Don't like to do that, but I will. Understanding that September 18th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Juliet Barnes.
Morning, Your Honor. Raymond Cook. Good morning. I'm Rob J. Kill on behalf of Mr. Barnes.
Judge, I'd like to give you a sad story.
Hi.
This is you being the considerate judge you are, this could be a tearjerker, but not being facetious. I met with I was appointed yesterday at 4 o'clock. I met with her last night at the jail. They told me she was in a long line of list people to be released. They didn't know when she was going to be released. I told her if she was released, she had to be here at 9 a.m.
Is this where we get to the sad part? Because she's not here.
She's not here, but
she got released. She's not here. I'll let you.
And she doesn't have a phone. So I called her friend at the apartment who was racing down to the 5th floor of the apartment complex. Judge, long story short, can I get a 1 week adjournment on this matter?
Did you cry? No. She's not here.
Judge, I understand that, but she may have been released at 1 o'clock last night. All I'm saying is, can we get a 1 week adjournment, please?
Here's what I will do. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000. Cash surety. That warrant I will not issue until
Late September.
September 16th.
Thank you, Judge. I appreciate your.
What?
So we could technically walk in next week then.
Okay, technically do anything you want. I don't know where you're walking into. The jail?
I'll just let that go. Thank you.
All right. Calls the case. People versus Sean Odom.
Alexander, on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Sean Odom. Mr. Odom, can you please state your full name for the record?
Sean Martell Odom.
Please, Your Honor.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Yes, Esteban.
Your Honor, it's come to my attention that Mr. Odom has tried to call the victims listed on the police report from his own pen 7 times since he was arraigned. He wasn't able to connect, but at this time I'd be asking that his phone just revoke, given that he's using his own pen to call her listed number after being arraigned and will not have contact.
Mr. Bird.
Respectfully, Your Honor, I haven't been presented with any evidence of that matter, and we just respectfully request that he keep his phone calls until it's presented to me in the court.
Well, certainly you'll be entitled to a hearing, but in the interim, defendant's phone privileges are hereby revoked. With that change, bond will continue. Thank you.
And what was
25th.
25th? Thank you.
Yes, sir. Court does call the case, People versus Cedric Green, no relation.
People.
Wow.
Good morning, Judge.
Good morning.
Beautiful day today.
Well, you're gonna change that.
No. Well, Judge, just for the record, Christina Costantino appearing on behalf of Mr. Green. Unfortunately, it doesn't appear that Mr. Green has arrived yet to court. I was
You
just
expecting him?
Yeah, sure. I mean, I was just assigned his case yesterday. So perhaps he has not received my letter yet, asking him to contact me and that sort of thing.
You sent a letter?
I did send a letter, always do.
Did you email?
Just in case. I did email. Yes.
Oh, okay.
Yes, I also called, but I have not been able to get in touch with him, unfortunately. So given that,
Mentioned that letter.
the letter,
Go
the mail, it's
Yeah.
not that quick. But I would ask respectfully for an adjournment of this matter so I can have a little bit more of an opportunity to allow the mail to get to him and, contact him.
Really? Constantino, you called him and you sent an email.
I don't know if that
We're waiting
contact
on
info.
snail mail?
I don't know if the contact info is valid. You never know. People's numbers change pretty rapidly these days.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thanks, Judge.
Thank you.
Can't say I didn't try.
You did. That was an epic fail. All right. Court calls the case. People versus Sherry Walker.
Yes, Your Honor. Brandon Bird on behalf of Sherry Walker. Ms. Walker, can you please state your full name for the record?
How you doing?
All right, we got a little bit going on here today, Your Honor. My client she wants to plea. She completed Don Farms. I did speak with Sister Prosecutor who said if we provide a certificate of Don Farms, that she would allow her to plead to a retail fraud second. Ms. Walker wasn't able to go back and get her certificate.
Go back where?
Go back to her cell to get her certificate. She did ask the officer, and I also
They were a little busy.
right, Don
Yeah,
Farms was a
yeah.
little busy. There's a lot of busy, but I did try to see if I could find Don Farms within the building, and unfortunately I wasn't able to get a hold of him. So I know Ms. Walker doesn't want to adjourn this anymore. And she wants to take responsibility for her actions and take Sister Prosecutor up on her plea. I'm wondering, first of all, if you have a copy and if you want.
Of what?
Of her Don Farm certificate.
That'd be a no.
Okay, if not, then,
Can I get it for her
What?
later on? Can I have her to send it to you later on?
I gotta give it to the prosecutor.
Okay.
Then, unfortunately, I did everything I could, but we're gonna have to adjourn this matter. But I would like to address bond on Ms. Walker.
Here's what I'll do. I'll let you address bond if you want. Rather than adjourn what would be a customary 2 weeks, I would adjourn it out 1 week if it's a certificate, because the other paperwork has to be completed for me to take the plea in any event.
Thank you.
Does that work for you, Ms. Walker? I realize you don't want it adjourned, but.
Okay, can you say that again? Repeat that?
I'll adjourn it out 1 week, which would be a shorter time period than I normally would.
Okay.
Because you've got the certificate, it just needs to get there. They also then have to fill out paperwork for me to take the plea. So I'll do that for you.
Okay, I appreciate it.
Okay,
Absolutely.
I'll do that for you. I'm not doing it for him.
Okay, good.
Okay.
Right.
Whoever you do it for, Your Honor, I appreciate it.
Probable cause conference will be adjourned September 18, 2025, 9 a.m. Bond continue.
Right.
Thank you. Court does call the case of the people versus Harris.
Morning, Your Honor, Raymond Cook for the people.
Harris?
Twice.
No, Judge, this one's here.
Oh, I told you, he knew his name.
Here and looking very professional, Judge. Christina Costantino, appearing on behalf of Mr. Harris, who is present here. Mr. Harris, could you please state your name?
Malachi Harris.
So I told you.
Judge, this is a date and time set for a PCC. I was just assigned on Mr. Harris's case this week, so we would be respectfully asking for an adjournment of the probable cause conference to ensure discovery is complete.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continue.
Thank you very much, Judge.
Malachi, thank you. Courthouse case, people versus Preston Jackson.
I should spell this for people. It is Carlo Maribel, who has been talking in and out. She's currently in an out situation.
What do you mean?
She's not present in the Zoom room, but she has been.
Where did she go?
I don't know, there's been no communication, so it might just be a while.
Okay, I'll have to pass your matter. We're gonna
Yes.
try to get your attorney.
She had
up on
told me
your-
she was trying to postpone my date till the 22nd, so me and my co-defendant would come in on the same. That's what she told me. She told me that she had postponed it to the 23rd.
Does he have co-defendants on the 23rd?
I know it's a zip code.
Brandon Jackson.
We were trying to make the cases meet up, but. Okay.
First name is Brandon. He's on the full third. And that is correct, Your Honor.
So your understanding is she was gonna try to set the preliminary examination for that date? Okay.
That's what she told me anyway.
I had no communications with Ms. Maribel, but I have no reason to doubt that.
Well, I don't have a reason to doubt it either. I just can't do that without her being present. So if it were an adjournment, I might be able to slip that by and then talk to her afterwards, but for a preliminary examination, I'd have to have her here.
Yes, sir.
So we'll send you back and then we'll try to get your call back up. Okay. Court does call the case of the people versus James Williams.
Morning, Your Honor, Raymond Cook for the people.
Christina Costantino appearing on behalf of Mr. Williams, who is present via Zoom. Mr. Williams, can you please unmute your device and state your name for the record?
Yes, ma'am. James Henry Williams III.
Okay.
Judge, we have been going through a rather lengthy mitigation process. I did receive mitigation reports this week. And so we will need a little bit of additional time to have some further negotiations now that those are complete. So we'd be asking for an adjournment of the PCC.
25th, September 25th, 2025, 9 a.m. Bond continued.
Thank you very much, Judge.
All right, thank you. Thank you, sir.
Thank you.
Court calls the case of the people versus Eric Brackman.
Trevor Mabo for the people.
Good morning again, Your Honor. Assistant Public Defender Davi Lebo on behalf of Mr. Brackman, who is in custody.
That's what I have. See you back there, Brackman? Yeah. Who do you have up? I'll take whoever you have. Huh?
We'll go.
Okay.
Eric Brackman.
Thank you. All right, what are we doing?
Your Honor, I do have a green sheet. We're going to be requesting an adjournment. I wasn't for some additional negotiations with the prosecutor. I was informed earlier today that they filed an amended complaint increasing the charge to third-degree fleeing and eluding.
Your Honor, that's true regarding my intent, except the court's not going to have that. I attempted to prepare it at the end of the day yesterday after discovering a prior felony on the defendant's record for fleeing and eluding, and then wasn't able to have it ready for the court this morning, but I intend to do so.
September 25th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. I think where is this person? Yoder. They got him. Her. Court calls the cases of the people versus Jessica Yoder.
Christina Costantino appearing on behalf of Ms. Yoder in case number ending in 1282 FY.
And Stephanie Cannon appearing on cases ending in 1283 and 1060.
Wow. You're
I'm here.
It was a lot quieter last week.
I haven't said anything.
What?
Yes, it was, Your Honor.
Yeah, you
Yes.
weren't here.
I wasn't here.
Everybody
I missed
commented
you
on how
though.
quiet it was.
I missed this whole thing.
We missed you too.
It was so sad.
Oh, constant. Nobody here missed it. All right, anyway, go ahead. What are we doing?
Well, first, Ms. Yoder, can you state your name for the record?
Jessica Yoder.
Thank you.
Judge, we need a little bit of additional time for further negotiations. We are trying to work out a global resolution for Ms. Yoder in all of her matters. So we would be asking for an adjournment of the PCC.
Are you saying in all of these matters or are there other matters elsewhere?
Well, Judge, she has these matters. She has a violation of probation up before Judge Washington in 14B, as well as one other matter in front of you. That's a misdemeanor matter.
Right. And so the one before Judge Washington, when is that set for?
Judge, it was supposed to be heard this week, but it got moved to the 18th. Is that correct, Jessica? The 18th of this month, September.
So what I'll do is I'll adjourn probable cause conference to the 25th, 2025 at 9. Bond will continue.
Thank you very much, Judge.
Court calls the case of the people versus James Abbott. Can we get
permission? My client, he suffers from, okay. His wife also has a device which helps him hear too. Now it's running.
Okay, will that work for you, sir? Or will that work for you?
It's a little better, yeah.
It's okay. That's
it's not a volume problem for me. I just hear like it's noise for me. So we're amplifying it a little bit more, but it's better.
But will it work for you or you want the other device? Whichever one, you want the one your wife has or you want this one?
Let's do this.
That one? Okay, very good.
Thank you.
The Honor, today is the date and time set for the probable cause conference. We will respectfully be requesting that a preliminary examination date be set.
Discovery is complete.
To the best of our knowledge, Your Honor.
People have their witnesses available the 23rd.
Yes, Your Honor.
Preliminary examination in person will be set September 23rd, 2025, 9 a.m. before Judge Freshour.
So I'm not sure if I put my appearance on the record. Did I do that? Lauren Brown?
Go ahead, now, put it on.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Abbott.
Bond will continue. All right.
Thank you
Thank
very
you.
much.
Thank you, sir. Court does call the case of the People versus James Chapman.
And is that on behalf of the people?
Brian Bowling on behalf of Mr. Chapman.
Thanks.
State your name for the record, James.
James Chapman.
Judge, we're here for a PCC today. I'm asking that this matter be set for an exam, and I believe all discovery to be complete.
Just motion for dismiss.
I dream, but yeah, that'd be nice.
Bless you. Would people have their witnesses available the 23rd?
We'll do our best, Your Honor.
Preliminary examination in person will be set September 23rd, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond will continue. Thank you.
Judge Barr.
Let's call the case People versus Tanisha Aiken.
Simpson Public Defender and Apple appearing on behalf of Ms. Aiken. No.
Aikens, will you state your name for the record?
Tanisha Akins.
Thank you.
Your Honor, we're asking for an adjournment for some continued plea negotiations.
Probable cause conference will be adjourned to September 25th. 2025, 9 a.m. Bond continue.
Okay, thank you. Okay.
Court calls the case of the People versus Curtis Damon.
Your Honor, the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Damon. Mr. Damon, state your name for the record.
Curtis Mitchell Damon.
Thank you, sir.
Your Honor, regarding the probable cause comments, we're asking for a preliminary examination date. I would like to address bond, and there's also a bond violation to address as well.
Yeah.
It's a little bit old. I think it's from early August, late July.
Well, let's get your preliminary examination set. What was the subject?
A positive scram.
So right now he's sitting here with no bond.
Correct, yes.
Okay. Discovery is complete.
To my knowledge, yes.
People have their witnesses available the 23rd.
Yes, Your Honor.
All right. I'll set preliminary examination September 23rd, 2025, 9 a.m. before Judge Freshour. Okay, go ahead. I have it in front of me now. From June 25th.
June?
That's the one I have. Well, yeah. August 12th, I'm sorry.
Okay.
Enrollment date was June 25th. I'm sorry. It's
Okay.
August 12th.
Just want to make sure I was coming from the right headspace. So I did have a chance to speak with Mr. Damon regarding the violation. He is going to admit to the violation today for the positive drug or the positive alcohol results. He did, for the court's information and I guess bond, relates bond as well, he did complete 30 days at Sacred Heart inpatient treatment. He got out and essentially relapsed. Right after that relapse, he had a mental health crisis and was hospitalized at
Health Source.
Health Saginaw. I did speak with his fiance, who's a social worker for Salvation Army, and she did provide me with all the information. He was petitioned by the court for hospitalization due to suicidal ideation. He completed, I think, 12 days there in an inpatient psychiatric hospital, and that's why he missed his last probable cause conference date that was scheduled for August 7th. There was also already the warrant in place that was kept in place. So given all that, Mr. Damon obviously has been through a lot over the last couple of weeks. He is back into compliance with his mental health treatment. He's on new medication, and I also verified this with his fiance that is really helping and has changed his disposition. New medication that he wasn't on before. He's also on abuse, thank you. And they referred him to AA, NA, and a support group, which he's been attending since leaving the Saginaw Hospital. So given all that, I think Mr. Damon is on the right track. He was fully honest with me about his relapse, and is really ready to get out, get his life back together, and stay sober. He's now has over a month sober. So we're asking for his release.
How long has he been in?
10 days.
Okay, go ahead.
And for the violation, I'd ask for credit for those 10 days. And he's willing to comply with any bond conditions the court may order moving forward.
Response.
Your Honor, I have some concerns. The court's aware he was on strength tether. He was still continuing to drink. It sounds like he was released inpatient. After that, he still continued to drink. What's been happening hasn't been working. And I don't know what else we can do other than keeping him in custody at this time in order to ensure that he continues not to drink and continues to remain sober. I have some concerns given that the underlying facts in this case involve his drinking as well. The report indicates he also had some warrants out related to some alcohol offenses at the time. He was threatening to harm another individual, was being rowdy and obviously resisting police officers due to his intoxication. So I just have concerns given this pattern of drinking, especially while on bond, his inability to control his drinking, that if this court were to release him, that he would just continue drinking and violating them.
I think things have changed. I think Mr. Damon admitted he relapsed in late July.
Here's what I'm gonna do. I'm gonna get through preliminary examination to his violation. I'm gonna sentence him to 30 days, credit 10. The balance he's to serve. And then this will be before Judge Freshour can take a fresh look at it at that point in time. All right. Thank you.
Thank you.
Court does call the case of the people versus Philip Barnhart.
Assistant Public Defender Ben Dunaway on behalf of Mr. Barnhart, who stands to my right. Would you state your name for the record, please?
Philip Barnhart.
What are we doing?
Your Honor, Mr. Barnhart is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
Report and receipt of the bond violation report from Community Corrections.
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor, and I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone. I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore it may not be a bond violation. However, I did double check X jail and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. So it's possible that certainly the THC could have been from before. The cocaine, I'm less certain of, with extremely heavy use, maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument, but.
Can I have just a second, Your Honor?
Sure.
So. Yeah, I just think there's possibilities that he's not used after being arrested and those.
What?
I mean, cocaine could stay in a system for up to a week if there's heavy use. So the failure.
Let's say, well, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, since I have 2 in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
I think I'm fine. I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's again my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones and he's still using. So I don't know that he should be out because at some point luck's going to run out. He's going to get behind the wheel and he's going to take somebody out. I don't have a vehicle.
Your Honor, I don't believe he's driving. The test certainly indicates use. Look, drunk driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point because he has been on bond since I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point would have undeniable jurisdiction to revoke his bond. I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all this is legitimately 4 and 5 with another one pending in Wayne County and he's still using. You're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I wouldn't absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that. We don't know if this is a one-time slip up. We don't know if he's used while he was on bond. I think the court could allow him to test today and that would solve the problem.
May I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his BAC was incredibly high. And I'm going to double check that before I get that search to the court. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is. People would request that the court find that the bond is an abuse of discretion and set a higher bond and remand.
I just don't think the circumstances have changed since the bond was set because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. There, it's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
Okay. I think it would not be abuse of discretion because of the length of time that has passed. So, we're already into August 2025. The positive test, we can't really deny it, but what we can say is he's not driving far. So the extreme danger to the community that comes with intoxicated driving is not present. Obviously, there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. I mean, the court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving. All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash or surety. So you're waiving your right to preliminary examination in these cases?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you will not have that hearing on either one of these matters, and that this will proceed to circuit court for further resolution.
Sir.
People also waive their right.
We waive, Your Honor. I do believe he previously posted $25,000.
Oh, are on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
It might have been PRs, maybe $25,000 PRs, but
I have on each of these that they're PR.
Oh, I apologize, Your Honor, my mistake. Thank you.
So people do waive.
We do.
Preliminary examination haven't been waived. Defendants bound over to circuit court on the single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pre-trial. Custody pre-trial date.
September 24th at 1:30 with Judge Conlon.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. The bond, as indicated, is set in each case. It will be changed from a personal recognizance to a $25,000 cash or surety. Defendant is remanded. Yes, you may. What was that date again?
24th, Your Honor.
Court does call the case of the people versus David Davis.
Defender Hannah Apple appearing on behalf of Mr. Davis. Could you put you now? Mr. Davis, will you state your name for the record?
David Davis. Thank you.
Your Honor, we are asking for an adjournment, and then I did wish to address bond on behalf of Mr. Davis.
Basis for the adjournment.
The adjournment, partially as part of the bond argument, but that he can begin treatment at Dawn Farms, which he has set up to begin next week. I'm sorry, tomorrow.
Inpatient.
It is an outpatient program. You revoked his bond last week for the positive test. He is willing to acknowledge that positive test. He did contact Dawn Farms before coming to court last week, completed the initial intake, and is scheduled for his assessment to begin outpatient treatment tomorrow at noon.
based on that and his admission to the cocaine and THC use, I'm asking the court to consider reinstating his personal bond so he can attend that appointment. I did provide verification to opposing counsel last week, a letter from the treatment provider and information regarding, of course, I think based on that assessment tomorrow is going to determine what level of care he's going to be needing. But I advised him that, I'd ask the court to order that he comply with whatever they recommend, if it's regular outpatient, intensive outpatient, or even inpatient treatment. And he's willing to do just that.
I would need is there any response from the people on that?
Your Honor, this is Mr. David Davis, correct?
Yes.
Trevor Mabo for the people. When the case was called, my office had some confusion as to what his first name was and who the case that was being called. So I wanted to enter my appearance for the record. Normally, it seems we don't get in the way of release to treatment orders, but this doesn't appear to be what defense counsel is requesting. This is a felony high file along with a high BAC charge where, in addition to the defendant's blood alcohol level being north of 0.18, he also had active metabolites for THC and cocaine in his system. He's given a relatively low cash surety bond and asked to submit to testing. And in the 3 weeks that followed his release, he was positive for both THC and cocaine in all 3 tests. And that's what was the basis for his bond revocation. I would not oppose a release to treatment, but I'm concerned about his narcotics usage if not done so.
Judge, I don't believe that statement is correct regarding the cocaine use. He had 2 positive tests for cocaine, which were shortly after his arraignment. He tested the next day, and then he did test, I think roughly about a week later, and there was a positive test for cocaine and THC. And he acknowledges
that powerful cocaine that's lasting a long time, like the last kid. Go ahead. I'm sorry. That was just me.
Yeah, I'm not going to make that argument for this case, but however, he did have a negative test for cocaine. There was still THC in his system. He reports that he has stopped use. He reports that since being incarcerated, he's also made contacts to try to work out a medical marijuana card upon his release. He will not use until that card is received and provided to community corrections. If the court allows.
I get it, but he shouldn't be using it all. He's got serious issues. And the very fact that he wants.
I mean, I think that's between him and his provider regarding the medical marijuana, but I think it's noteworthy that he had a negative for cocaine. He's been incarcerated for a week. He set up treatment. He has it scheduled to begin tomorrow. I would just ask, based on all of that, he is also on a scram tether. I understand the basis of part of the OWI is obviously BAC. There was no issue regarding alcohol consumption on bond. He still has a scram tether on. I don't think that that's been of any issue, and he's doing everything he can to show the court that he's compliant and willing to work that out. And he's been in custody the last week. I would say fairly from our conversations, has very much learned his lesson and understands if there's even the slightest slip up that he's going to be back in here and he's not going to have a chance to get out. But I would just ask for the opportunity so that he can keep his treatment appointment tomorrow that he's scheduled. And
all right, here's what I'm going to do. I'm going to need an order. I'll allow him to go to Don Farm, but prior to him going, I realize he's got a scram tether. He's going to have a GPS tether on his other leg, because if he leaves that program, doesn't cooperate in that program, he's going right back in.
Understood.
So I'll need an order.
Okay, I will prepare that today.
Thank you, Your Honor.
All right, thank you. What is it?
It's going to put you.
You can. Hold on.
Actually, I'll do all your.
And I returned this out to the 25th. It's about to continue with that modification.
Just until I get the order to the court and they can put it out. Hopefully today.
Court calls the case of the people versus Douglas Brown. All I have. So I don't like the way these are put up. So what?
Douglas Brown.
Douglas Brown.
Oh, I'm sorry. He's on Zoom. My apologies. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Brown. Mr. Brown, will you state your name for the record?
Douglas Brown, sorry.
Thank you.
Your Honor, we are asking the court to consider a very brief adjournment of 1 week. Mr. Brown is retaining counsel. There's been communication regarding Mr. Vincent's office, and I spoke with Amanda
Are they going to
today.
enter their appearance?
They plan to file that all today. the appearance and the substitution.
Did you talk to Mr. Vincent?
No, I
Or-
talked to Amanda.
Okay, then I'll believe it.
Okay.
Thank you.
You just need a week? What did, so you, my condolences to your family, first of all. And secondly, though, you guys sent him here alone last week. So I don't know what?
As you can understand why I had to.
No, I understand why, but yeah. I don't know what, I can't remember what he did.
I'm sure he messed it up.
Oh, he did, but I just don't know what day.
We do have a matter in front of you next week on the 18th. So it most likely was that.
That was, so just so you know what he said. He
What's that?
walked, just so you know what he said. He walks in and I said, "You're here alone." He said, "Yeah." I said, "Okay, so what dates did they give you?" He said, "They just said set any date." I don't think that's what you said. That's okay. But if,
And that's how I know that you know me, Your Honor.
yes, I know, you gave him, you would have given him a date and he would have, well, anyway. All right, I will on this one, if it's gonna retain, then I'll adjourn it out 1 week.
Thank you, Judge.
Go with the other 135. September 18, 2025, 9 a.m. bond continue. All right. Thank you, Mr. Douglas. Court calls the case, People versus Ishmael Davis.
Assistant Public Defender Dodgy Leave on behalf of Mr. Davis, who is approaching.
Your name, sir?
Ishmael Alexander Davis.
Thank you.
And Your Honor, I do have a green sheet, or I will be retrieving one in a moment, but we're going to be requesting an adjournment in order to continue negotiations, but hoping to wrap some additional cases into a global resolution in this matter.
September 25th, 2025, 9 a.m. Bond continue. Court calls the case of the People versus Elia Bellows.
Trevor Mayville on behalf of the people.
Yes, I thought. Council approach, please.
All right. 14A, District Court for County of Washtenaw, State of Michigan, is now back in session. The Honorable Judge, they said, tonight.
You may be seated. We recall the case of the People versus Bellows. I wanted to discuss, council, state your appearance.
Ashley Bellis for the people.
Assistant Public Defender Ben Dunworth, on behalf of Ms. Bellows, who stands to my right.
And I just wanted to inform council that I actually know Ms. Bellows. I have not seen her. She is quite grown up now. I've not seen her since she was very little and running around everywhere causing kid havoc. I'll just put it that way. All right. So I wanted to let council know and of my and get some clarification in terms of who might be potential witnesses in the case, because I do know her grandfather, her father, and her mother. I explained all that to council. From my understanding and speaking with council, at this point, I am not going to recuse. I would handle anything. Will not be handling if this matter is set for preliminary examination. I will not be handling it. I would not do that. And if it comes to anything where a decision has to be made, I would refer it to a different judge. But as long as it's going on, I understand there's no objection to the court proceeding.
That is correct, Your Honor. I think that is what we discussed.
The defense is okay with everything the court just put on the record. Thank you.
All right, very good. And so you'd like an adjournment of these proceedings. So I will grant the adjournment. I will set probable cause conference in this matter for September 25th, 2025. All right.
Okay,
Bond continued. Thank you.
come back and call you.
Court does call the case of People versus Robin Lee Finney.
Trevor Maybell for the people.
Assistant Public Defender Hannah Apple, standing in for Ms. Perny on behalf of Ms. Finney, who's approaching now. Your Honor, we are asking for a release to, or an adjournment. I believe the court already signed a release to treatment for Ms. Finney. Okay. So we're asking for an adjournment for that to be conducted. If she completes treatment, my understanding there's a resolution that will be offered.
But is that treatment already set up, or have I just ordered it and it hasn't been accomplished?
I have. I did my access call yesterday to Bear River, Your Honor, and we've already been accepted.
So they're setting, so the jail is setting you up so that you can go to Bear River.
Correct. They've already
Okay.
done. I just had to do it updated, sir.
Did they give you a time frame on anything?
Today I finished my call to talk directly with Bear River as far as with them, like, they just want to go over a couple of things and then we're just waiting on transport.
Got it.
Thank you, Your Honor.
Let's do this. Just so that we can keep track. I don't want to go out to October 9th, but I want to give time in case there's transport. She may not be able to communicate directly with anyone immediately, so I'll adjourn probable cause out to September 30th.
Okay. As soon as you get their call.
2025, 9 a.m. That's on a Tuesday.
Correct.
And we can take a look at that. All right.
Thank you, Your Honor.
If I don't see you before you go, good luck.
Thank you, Your Honor. Thank you.
Court does call the case, People versus Robert Gallet. He's in custody. In Zoom.
Assistant Public Defender Hannah Apple again on behalf of Mr. Let, standing in for Ms. Perny.
Yeah, but I don't.
My name is Robert Gallet, also known as Lynn.
Oh,
Oh,
Mr.
right.
Let.
Got it. Okay. I see the way they put the name.
No
Different.
problem.
All right. What are we doing?
Your Honor, it appears we are asking for an adjournment.
Is Mr. Killowald here?
He was. I believe I also, Mr. Killowald did sign, I don't know if the court's in receipt of this, I'm sorry. A release to treatment. Mr. Killowald also signed off on as part of the request,
All right.
making this request. And then looks like Ms. Douglas and Ms. Perny. The court does not have this yet. I'm sorry.
All right. Do you have any problem with the public defender standing in for the purposes of this hearing for Mr. Killowald?
Oh, no, no problem, sir. Everything's good. You go.
Okay, thank you.
No problem.
Yes, so I believe it discusses on there that there's we're trying to secure some housing as well, so release to treatment in the.
And there was an order submitted. And let me give this to you, and let you process that. Yeah, we go into the file. Okay. All right. So you want an adjournment on these, the 30th?
Please. Sounds good.
And just to make sure, all right. Probable cause conference in these matters will be adjourned to the September 30th, 2025, 9 a.m. Bond will continue on this. All right, thank you.
Thank you, sir. Did you sign the request for treatment, sir? We're able to.
For the treatment?
Yes, sir.
Yes, I'm gonna sign that. I'm just
Thank
having
you
my
so much,
staff
ma'am.
process everything. Yep,
Yes, sir. I
okay,
appreciate your help. Thank you so much.
thank you. Court does call the case People versus April Black.
Stephanie Cannon on behalf of Ms. Black, who is approaching.
April Black.
All right, court has before the plea form. Is that what we're doing?
Yes, Your Honor.
All right, Plea form indicates that the defendant will be pleading guilty to the charge of disorderly person jostling as a count 3. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. Defendant is agreeing to pay restitution for damage to the police car.
Yes, Your Honor, that is correct.
And also that the prosecutor will recommend prosecutors defer. That's the court's full understanding. Is that it?
Your Honor, that is my complete and full understanding of the agreement.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony about you, the whole truth and nothing but the truth of the matter?
April Black.
Ma'am, it is this court's understanding that you're going to plead guilty to the charge of disorderly person jostling. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
So we said.
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington, 14B District Court. You want to talk to her or you want me to?
No, Your Honor, she asked me who was Judge Washington. I was just.
Oh, who was Judge?
Yeah.
Really?
Yeah,
What'd
yes.
you say?
I said that Judge
Tell
Washington
her.
is just an imaginative, wonderful person, and she should be happy to be sentenced in front of her.
You like her better than me, Cannon?
You don't.
Not asking.
Sure. Your Honor, you
Never
both
mind.
have
I'm
such
not gonna
great
take-
attributes
All
of
right.
strength.
You understand that you'll be sentenced before Judge Washington.
Yes.
All right. Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of June 22nd, 2025, at the location of Alston Court in Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
I pushed a cop.
You did what?
I pushed a cop.
A cop,
Yes.
police officer?
Yes.
You pushed them?
Yes.
And that was in public?
Yes.
And did that create a disturbance or
Yes.
when you did that? Sure it did. All right. Ma'am, I do have to advise you, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, that any sentence recommendation or evaluation the court would no longer be bound by, and you would not be able to set aside your plea. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Your Honor, the defense is not. No, Your Honor.
And have I complied with the court rule? Would it be proper to accept its defendant's plea?
Yes, Your Honor. It would, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
October 16th at 10 a.m.
October 16th, 2025, 10 a.m. before Judge Washington.
Thank you so much, Your Honor.
Bond will continue. Thank you.
Oh, Your Honor, can we address bond? My apologies. I'll go as quickly as possible. As the court is well aware, my client has been untethered during this whole time frame.
I'm going to leave that up to Judge Washington after her assessment.
Thank you, Your Honor.
Thank you. Let's call the case of the people versus Alua Gillis.
And Alexandra on behalf of the people.
Assistant Public Defender Chelsea Vergil with and on behalf of Lua Gillis. Please state your name. Lua Gillis.
What are we doing?
Your Honor, we are asking for
an adjournment after Ms. Willis has been found competent, just to continue a plea discussion, and I would ask to address bond.
Just come here.
Yes.
And you're the court receipt of the
Yes, I do see it. I think she is competent to stand trial. All right. No other evidence
No, Your Honor.
from either
No, Your Honor.
stipulate to the report. The court, based upon that report, would find that the defendant is competent to stand trial, which specifically indicate the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent. All right, I'll need an order presented to the court.
Yes, Your Honor.
All right, you're asking for this to be set for PCC.
Yes.
Set a probable cause conference in this case for September 25th, 2025, 9 a.m. Bond continue.
Can I address bond?
Certainly.
She is being held on another matter, so I'm asking for a low cash bond so that once those matters are resolved, she could potentially get out of custody. Once out of custody, she plans to live she lives in Ypsilanti. She lives very close to her parents.
When's the next hearing on the other matter?
It's Wednesday, September 17th. And then I have October 22nd.
And Your Honor, I'm not sure of the other matter. She is, her bond is denied. She has a VOP hold for stalking victim right now.
I didn't think her bond was denied. I thought it was 20,000.
It is 20,000.
She is being held on other matters, though, Your Honor.
A VOP?
Correct. She pled two different stalking cases this year.
And I don't know why I'm hearing bond on this one, but go ahead, counsel.
I believe that the alleged violation would be this case. However, she does out of custody do outpatient treatment with CMH. Again, she lives near her parents who are supportive, make sure she gets that treatment. She's at risk of losing her disability benefits, so she'd really like to be out of custody. We have no objection to a GPS tether.
And Your Honor, I just wanted to put on the record that she is on probation for stalking the same victim, and this violation is her continuing to stalk the victim. She's had all these things put in place with probation.
Motion for bond reduction is denied. Bond will continue. Thank you. Court does call the case of the people versus Jay Dingman.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Dingman, who does appear via Zoom from the Washtenaw County Jail, Your Honor. Sir, can you please state your name for the court?
Jay Hoan Dingman.
Thank you. Your Honor, I'm respectfully requesting an adjournment. I'm asking if the court would consider possibly 1 week. I did receive an offer from the people.
I don't like these 1 week adjournments. I'm just letting you know.
I understand,
So
Your
it better
Honor.
be all taken care of. I'll adjourn it out 1 week.
He
September
refused-
18th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls the case of the people versus Adam Harris.
Alexander on behalf of the people.
Assistant Public Defender Hannah Apple, appearing on behalf of Mr. Harris, standing in for Mr. Kearney on this case. Mr. Harris, when you are approaching, state your name.
Adam Harris.
Thank you. Your Honor, we are asking that this matter be set for a preliminary exam.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available the 23rd.
We'll do our best, Your Honor.
Preliminary examination in person, September 23rd, 2025, 9 a.m. That's before Judge Barr. Bond will continue.
All right, thank you, Judge.
Court does call the case, people versus Charles Blakely.
Raymond Cook for the people.
Stephanie Cannon on behalf of Mr. Blakely, who's appearing to our right. Please state your name for the record.
Charles Blakely.
Mr. Blakely, you indicated that you do have a hearing problem. Do you need anything from the court to hear better?
I don't think so.
Okay.
Thank you.
You're good?
I think
Okay.
Your Honor, we are requesting adjournment of this matter for meaningful consultation between the client.
Probable cause conference will be set September 25th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Roman Hop.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Hoff, who's approaching now. Mr. Hoff, will you state your name for the record?
Ramon Hoff.
Thank you. Your Honor, we're asking that this matter be set for preliminary exam.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 23rd.
We'll try, Your Honor.
Preliminary examination in person, September 23rd, 2025, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond continue.
Thank you.
Court calls the case of the people versus Jamie Burke. Did I not have an assignment on this?
No.
What's no mean? Did I,
No sign. Oh.
this was a PD
This-
case,
yes.
there was no assignment?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Burke. That is correct, however, or Mr. Burke, we state your name for the record.
Yes, Jamie Burke.
Thank you.
Hello, Your Honor. Good
Hello.
morning to you.
Good morning to you.
Your Honor, we're asking for an adjournment. There's some restitution payments that he needs to begin making before there will be any consideration for a resolution.
No objection.
I have absolutely zero objection to that either. Just gotta give me 2 weeks to make a decent payment because I just started a job. If you can understand that.
Probable cause, September 30th, that's a Tuesday, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Really appreciate.
Thank you.
I hope you have a wonderful day.
You do the same.
Absolutely, you're.
Thank you. Court calls the cases of the people versus Kyle Humphreys. All 6 cases.
Assistant Public Defender Ben Dunaway on behalf of Mr. Humphreys, who stands to my right. State your name for the record, please, sir.
Kyle Brenton Humphreys.
Thank you.
Your Honor, this is the date and time for a PCC. Mr. Humphreys would like to request exam on all matters, and we would like to address bond.
All discoveries complete on all these cases.
Yes, Your Honor.
People have their witnesses available on the 23rd. Preliminary examination in person will be set September 23rd, 2025, 9 a.m. All of these matters will be before Judge Barr. As the bond.
Your Honor, on August 28th, my client turned himself in to the police station. He advised the police that he thought he had a warrant and he had been committing some crimes around town to support his drug habit. My client, my client has a single prior conviction for nonviolent retail fraud in the 2nd degree, nothing
So
else.
aren't part of these cases bond violations for his other cases?
Are they what? Sorry.
Aren't some of these cases bond violations on the other cases?
I think some of them are. I know one of them dates back. I did charge these cases. But I'd have to check the date of offense, right?
I think they might be probation violations on his retail fraud in Wayne County, but I don't think it's a bond violation.
I've got complaints for conditional release on this defendant. Go ahead with your argument.
Your Honor, he has no violent charges. He has no violent convictions. We believe his guidelines are 0 to 11. He did turn himself in. He's been fairly forthcoming. We'd ask the court to release him to treatment.
I will sign a release him to inpatient treatment.
Okay.
It's not an issue.
That's all we're asking for, Your Honor. Thank you.
Well, should have led with that. All right, motion. We'll sign. If I have an order, I'll do it.
Thank you.
All right.
Thank you. I will submit the order to the clerk of the court.
Court calls the case of the people versus Derek Stewart.
Your Honor, Raymond Cook of the people.
Assistant Public Defender Hannah Apple, appearing on behalf. Stewart, sitting in for Ms. Perry. Mr. Stewart, will you state your name for the record?
Mr. Derek Stewart.
Thank you, sir.
Your Honor, we are asking for an adjournment. My information is that we do not have a competency report
Wait a
received.
minute, I asked for a bond, a bond. We're not the same attorney I had the other day. We were asking for a PR bond. Hello?
Your Honor, if you could give me one moment to check the file regarding the bond request, please. Thank you.
We were discussing a bond Tuesday, Wednesday, no, Tuesday. You're not the same attorney I had Tuesday.
One moment, Mr. Stewart. Your attorney had to leave court.
It's 4/24/25. I denied the bond request. Then did he disappear? No, and I had a competency. I have a competency. And then he didn't appear. His bond was denied.
I didn't appear. What you mean I didn't appear? I was in jail.
Well, he had a bond violation. His bond was denied.
But they said you couldn't go ahead with the bond violation until the competence.
Sir?
Your Honor,
Go ahead.
I believe the information you say is correct in regarding the bond request. Mr. Stewart is asking the court to consider a release on a personal bond. He reports that he would stay at the Delana Center if released. We do have updated contact information. He has been in custody over 100 days.
Probable cause conference, September 25th, 2025, 9 a.m. Motion for bond reduction is denied. Bond will continue. Court does call the case, People versus Jason Campbell.
Are you ready to go to the people?
Sorry, Stephanie Kane on behalf of Mr. Campbell.
Sorry to wake you.
My apologies, Your Honor. Your Honor, on behalf of, but clearly not with, we have attempted to reach out to Mr. Campbell to no avail. I'd ask for an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court does call the case of the People versus Mark Jackson.
Good morning, Your Honor. Assistant Public Defender Alexis Zerbst with and on behalf of Mr. Jackson, who is approaching. Can you please state your name for the record?
Mark Jackson.
All right, I have before me a plea form that indicates that the defendant will be pleading no contest to the charge of attempted possession of a loaded firearm in a vehicle. That is a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs and mandatory forfeiture of the device. Upon a successful plea to that charge, count one would be dismissed. That is the court's full understanding of the agreement.
Check here.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Mark Jackson.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of attempted possession of a loaded firearm in a motor vehicle. It is a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court cost, and mandatory forfeiture of the weapon or device. You understand that, sir?
Yes.
You do understand what a no contest plea is?
Yes.
All right, two things about it. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would sentence before Judge Washington in the 14B District Court. You understand that? Basis for the no contest plea?
Lack of recollection, Your Honor.
All right. Sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes,
You understand you're giving up your right to appeal of right.
yes,
You on probation or parole?
no,
Has anybody promised you anything other than what's been stated on the record
No.
to get you to plead? Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free
Yes.
will.
yes,
All right. Court has been provided and has reviewed Washtenaw County Sheriff's report for their case number 22-84676. Any objection to the court having reviewed that report?
No objection, Your Honor.
Based upon a review of that report, the court would find that there's sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rules, you would not be entitled to, or the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
yes,
You also understand that you would not be entitled to withdraw your plea.
yes,
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, sir.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count two. Count one is dismissed. A pre-sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be
October 9th at 10 a.m.
October 9, 2025, 10 a.m.
Your Honor, if we may
for
briefly address bond when appropriate.
Judge Washington briefly, and hopefully it's relevant to everything. Go ahead.
Your Honor, we would be asking for his release on a GPS tether. I believe Mr. Jackson entering a no contest plea shows he's serious about this case and ready to get this taken care of. I know there were some previous issues because of his incarceration in Georgia. However, he does have family support. Mr. Jackson's father is present in the courtroom. That will be another safeguard to make sure that he stays accountable and takes care of this case. He also does have a job lined up as well. He was working prior to coming into
Isn't
custody
this the
today.
argument that I heard?
Yes, Your Honor, but I believe that the different circumstances today is that he's admitting our responsibility by pleading no contest.
Your Honor, I'm not opposing the GPS tether.
Wow. All conditions will remain in effect. Defendant may be released on a $10,000 personal recognizance bond with the GPS tether prior location tracking prior to release.
Thank you, Your Honor.
Court does call the case People versus Michelle Campbell.
Morning, Your Honor. Raymond Cook to the Commission.
Brian Bowling on behalf of Ms. Campbell, Your Honor. Ms. Campbell? She's not here.
That didn't happen, huh? Okay.
Your Honor, I wasn't able to get in touch with her. I'd ask you to adjourn it. Give me that consideration.
Bench warrant, 10,000 cash surety. That warrant will issue immediately.
Thanks, Judge.
Let's call the case of the People versus Gerald McKinney.
Assistant Public Defender Chelsea Vergils with and on behalf of Gerald McKinney. Mr. McKinney, please state your name.
Gerald McKinney.
Can you stand here?
What are we doing?
Where's the payment?
I'm sorry, Your Honor.
Walmart.
We are,
Pontiac Trail.
I'm sorry. It's come to light. I believe there is further discovery issues. I thought we were ready to proceed to exam. However, I'm asking to adjourn now for further discovery.
Probable cause conference, September 25th, 2025, 9 a.m. I'll need a green sheet. Continue.
Thank you, Your Honor.
Court does call the case People versus Marquetta Clemens. Wait, why are they writing?
Assistant Public Defender Natalie Pate for Ms. Clements, who I do not believe is present, Your Honor. I do not have an explanation for her failure to appear outside of the fact that the only contact information I have for her, unfortunately, is a mailing address. For the record, I would request an adjournment.
This warrant will issue for defendant's failure to appear bond is set amount of $10,000 cash surety. That warrant will issue. Court calls case of the people versus Maxwell Nowak.
Raymond Cook for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Nowak, who stands to my right, please state your name for the record, sir.
Maxwell Nowak.
Maybe approach.
Briefly. All right, what are we doing here? You're seeking an adjournment on this.
Yes, Your Honor, I have to now because we do not have discovery, and I found out yesterday the reason why was because this motion was filed, which I do stipulate to the protective order, Your Honor. However, my client has been sitting a week after we requested discovery before this motion was filed. I've been unable to review any discovery with him.
If
So
the
we do
whole
need to
issue
adjourn.
was just the personally identifiable information, you guys were at the bench just talking about that with me. I don't know why I needed to be part of that conversation. You guys should be able to work it out. Just
I
talk
agree,
to
Your
each
Honor.
other.
I
I'll
agree.
adjourn it out 2 weeks. Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Carlton Cross.
Assistant Public Defender Natalie Pay on behalf of Mr. Cross, Your Honor, who I do not believe is present. I do have an update. I did speak with Ms. Stewart with Jail Services, who indicated that although he did have a released inpatient treatment, I cannot represent to the court that's where he was released. He posted his bond on August 29th. He did sign an ROI with Sacred Heart. I did contact them and leave a voicemail asking for confirmation of his presence there. I did also leave a voicemail at his personal number. However, unfortunately, did not hear back. And for the record, do not know where he is and would respectfully request an adjournment.
Bench warrant will issue bond 10,000 cash surety. And warrant will issue immediately. That's in both matters.
Thank you, Your Honor.
Court does call the case of the people versus Enda Nielsen Osorio Martinez.
Assistant Public Defender Chelsea Beals with and on behalf of Nelson Osorio Martinez. Please state your name.
Hello, my name is Eddie Nelson Manrique Osorio Martinez.
We are asking to adjourn on this case. Unfortunately, I was unable to meet with my client.
September 25th, 2025, 9 a.m. Bond continued.
Okay.
Court calls the case of the people versus Malik Xavier. Cleveland. Yeah, that's not what they, okay, gotcha. Malik Cleveland. I'm sorry.
Raymond Cook for the people.
Stephanie Cannon on behalf of Mr. Cleveland. Mr. Cleveland, could you please state your name for the record?
Malik Cleveland.
And Your Honor, we are going to be requesting an adjournment of this matter. Plus, I have a stipulated order in agreement to allow my client to travel. I'm presenting both to the court.
Where?
Your Honor, he has a prepaid cruise to Mexico set up. Prepaid, he's already paid for the cruise to Mexico.
I know what prepaid means.
My apologies.
Really?
Hey, Judge. How can I help you, Your Honor?
Just about done with you. Well, when is he going to Mexico?
He goes in October 13th, I believe, and comes back on October 18th.
Correct. Probable cause conference will be adjourned to September 30th, 2025, 9 a.m. Bond continued.
And Your Honor, did you know I had the order already for you? Judge, for you? No? Okay.
I guess you wanted to thank you. Thank you for doing your job. All right, court calls the case, people versus Vandalist Patterson.
Assistant Public Defender Chelsea Beals with and on behalf of Landis Patterson. who approaches. Mr. Patterson, please state your name.
Landis Patterson.
Thank
How you
you.
doing?
We are asking to adjourn for a mitigation report that should be coming in soon.
Pardon?
It should be done soon.
September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case of the people versus Quan Patterson.
Assistant Public Defender Don B. Lebo, Mr. Patterson.
Your name, sir? Quan Patterson. Thank you.
And Your Honor, would be requesting to set this matter for preliminary examination, please.
Is all discovery complete?
To my knowledge, Your Honor.
People have their witnesses available the 23rd. Preliminary examination in person, September 23rd, 2025, 9 a.m. That's before Judge Freshour.
Thank you, Your Honor.
Bond continued. Court calls case of the people versus William Riddle.
Assistant Public Defender Chelsea Virgils with and on behalf of William Riddle. Mr. Riddle, please state your name.
William Michael Riddle.
Your Honor, we are asking to adjourn for a continued plea discussion, and I would ask to address bond.
Probable cause conference, September 25th, 2025, 9 a.m. As to bond.
Your Honor, I believe this is the only thing holding Mr. Riddle. He does have a plan of a place to stay in Ann Arbor with a coworker. He was previously employed and he has communicated with his boss so that he can return to employment. He plans to continue going to NA and AA meetings. And we have no objection to a GPS tether. I ask you to consider a personal bond.
Response.
Object to any modification of bond. This is a very serious case. In this case, we originally requested a $15,000 cash surety bond. We were given a $15,000. In this case, he lunged at the victim out of nowhere, grabbed her by the throat, and strangled her until she was unconscious on the ground. She also informed officers he had strangled her 2 weeks prior. This incident was witnessed by someone who saw him strangle her to the point where she was limp and lying on the ground. When officers arrived, he was trying to help her back up. She had marks on her neck and had a sore throat, and her skin was warm to the touch. I mean, I have concerns given the facts of this case that she was strangled to the point of unconsciousness. Also, the fact that it was witnessed by someone. And he does have a history of retail frauds, innovation second, CNC second, larceny, controlled substance use. He does have 2 holds, one out of Ingham County for collections and another for retail fraud, 3rd out of Jackson. So at this point, I would be asking for our original request of $15,000 without the 10% or that bond remain as set.
I don't want to get into arguing about the facts, but he does certainly dispute them. Regarding the holds, he has already spoken with Jackson County, I believe. In both cases, he just owes a couple $100. I think that staying away from the complaining witness is sufficient to ensure the court that no further trouble will be had in this case. I don't expect any bond violations. While he does have a criminal history, I don't think that anything of this nature is within his criminal history. And he does have a plan for a stable lifestyle. So I ask again the court to consider a personal bond.
Motion for bond reduction is denied. I won't up the bond or send it to the cash or surety, but I'm denying his request to case bond. Thank you. Court does call the case People versus Abdul Scott.
Public Defender Natalie Pate with and on behalf of Mr. Scott in both cases, who is approaching. Please state your name for the record, sir.
Abdul Scott.
Thank you.
Thank you, Your Honor. I have discussed both matters with my client as well as the people. To my understanding, discovery is complete. We are asking to set for exam, please.
People have their witnesses available the 23rd. Preliminary examination in person, September 23rd, 2025. 9 a.m. before Judge Barr on both matters. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Colin Spry.
Public Defender Natalie Pate with and on behalf of both matters, who's approaching. Please state your name for the record, sir.
Colin Joshua Spry.
Thank you. Thank you, Your Honor. I have discussed both of these matters with the people as well as with my client. At this time, we are asking to set both matters for preliminary examination.
All discovery is complete.
Yes, Your Honor, to my knowledge.
We'll have the witnesses available on the 23rd.
We'll do our best.
Preliminary examination will be set September 23rd, 2025, 9 a.m. before Judge Freshour in both matters.
Thank you, Your Honor.
Bond will continue. Court does call the cases of the People versus Gary Taylor.
Assistant Public Defender Alexis Zerbst with and on behalf of Mr. Taylor.
Gary Taylor.
Your Honor, can we briefly approach?
Briefly. All right, you're requesting an adjournment.
Yes, Your Honor, and when appropriate, may we briefly address bond?
During all of these matters, probable cause conference to September 25th, 2025, 9. As to bond.
As to bond, Your Honor, we'd ask for either a reduction in bond or a release with maybe some intensive drug testing. Mr. Taylor has been in custody for about 30 days now. He's learned his lesson about what previously transpired. He has better support set up. He will be staying with his mother and father in Belleville. He does have a job he can get back to, working 6 or 7 days doing construction and asphalt. He does have 2 children that he does provide support for and would like to be able to keep seeing and spending time with. Like I said, Your Honor, he did learn his lesson. He would just like a second opportunity to prove to the court that he is willing and able to comply with any court orders. So for those reasons, you're requesting either that reduction or a personal bond with intensive drug testing.
Any response? In looking at everything and looking at these 3 cases, at this point, I'm not going to change the defendant's bond. Defendant's bond is denied. Motion for bond reduction is denied. Bond will continue. Thank you. Court does call the cases of People versus Man Davis.
Your Honor, Assistant Public Defender Ben Dunn with my client, I believe, just went to the bathroom. Could we pass this matter?
All 4 of them? Yes, I'll pass. What?
Should be walking in any moment. He was in the room.
Ben Davis?
No. This time. Good afternoon, Your Honor. Edward Lucas on behalf of Man Davis in 1167 and 1367. I'm dropping my door. Give him all my.
No, you're good. I'm just.
Lost Lauren. We lost Lauren. He's around here. He lost.
Lauren?
Yes.
No, he only know 22 separate.
I think
don't know district.
I think it's his birthday. So he's like older now. He's moving slow. Make sure to tell him that. Where is he?
I'll check in the office, Your Honor.
Okay, we're gonna lose you now.
I do know that they have talked to Lauren and they were also seeking an adjournment. Adjourn.
Brian Bowling for the PD's office, Your Honor.
All right, you're seeking an adjournment.
That's correct.
How much time are you looking for?
2 weeks.
2 weeks. Probable cause conference in these cases will be adjourned to September 25th, 2025. 9 a.m. Bond.
That's awesome. Thank you, Your Honor.
Thank you.
Thanks, Judge.
Thank you, Mr. Davis. Court calls the case People versus Elizabeth Hill.
Trevor Mabo, for the people, Your Honor.
And good afternoon again. Edward Lucas on behalf of Elizabeth Hill is approaching.
Elizabeth Hill.
Thank you. She's waving his hand.
Waving her right.
Ma'am, is that correct?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. Mr.
Thank you.
Peters.
Your Honor, we acknowledge receipt of the information, stand mute, waive its reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. Pretrial in this matter will be set for
November 4th at 1:30.
November 4th, 2025, 1:30, Judge.
Thank you, Your Honor.
Thank you. Bond continue. Case of the people versus Marcus Earl, 2 cases.
Good afternoon, Your Honor, Raymond Cook for the people.
And good afternoon, Your Honor. Brendan Davalski appearing on behalf of Marcus Earl. Your Honor, as you can see, my client is not present. As it relates to at least one of the cases, Your Honor, that being 25 F5 5525-FY, that's the one I'm representing Mr. Earl on. Today was a review date for the competency. I was before Your Honor back on, it looks like June 12th of this year. At that time, I had referred my client for competency. It was Zoom at that point in time. I had a very difficult time communicating with my client. It has not improved at all, Your Honor. I haven't been in touch with him since that date. I've spoken to his mother numerous times. I know that I had actually emailed her the order that was sent to my office from the Forensic Center about the appointment at the Forensic Center on August 8th, 2025. It's my understanding that he never participated in that interview. I cannot get him to communicate with me. She said that he will not attend voluntarily. At this point in time, Your Honor, I'm going to defer to you to determine what the best course of action moving forward.
Best I can do is just issue a bench warrant.
Okay, I'll let.
Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately. And just so that you know, and you can let the defendant know that he also has another case pending that he's not yet been arraigned on.
I absolutely will, Your Honor. Thank you.
All right.
Have a good day.
Court calls the cases of the people versus Edward Harris.
And then on behalf of the people.
Stephanie Cannon on behalf of Mr. Harris, as it relates to case number ending in 1287.
Good afternoon, Your Honor. Jonathan Sachs for Edward Harris, case number ending in 1250.
Your Honor, despite my best efforts of reaching out to him multiple times, I have not had any communications with my client. I'm asking for an adjournment.
Exactly the same, Your Honor. I'm hopeful he's doing something exceptional today and we'll be here next time.
Would request a bench warrant.
Bench warrants will issue for the defendant's failure to appear in both of matters. Bond in each case will be set in the amount of $10,000 cash surety. Those warrants will issue immediately.
Thank you, Your Honor.
Thank you. Case of the people versus Terry Lanier.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Lanier.
Terry Lanier. Thank you. You're requesting an adjournment.
I am, Your Honor. I was assigned yesterday for Mr. Lanier, and it was good to meet him today, but I still need to receive and review the rest of discovery and spend some time talking to Mr. Lanier.
Nothing to add, Your Honor. I believe discovery had been completed prior to the new appointment, but I'll work with Mr. Sachs to make sure they have everything.
September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the cases of the people versus Todd Reber.
Different others for the people.
Robert, on behalf of Mr. Lieberg.
Public Defender Natalie Pate standing in for Public Defender Lauren Perny on behalf of Mr. Reedberg in the cases ending in 0694, 0793, 0906, 0718, and 0891.
Your Honor, Mr. Reberg was previously released to treatment. It's my understanding that he is currently inpatient at Sacred Heart in Richmond, Michigan. The facility has not brought him forward today. We are working.
Is he there?
If I may, Your Honor, so Miss Perny reached out to Sacred Heart and left voicemails and did not hear back from any sort of human, but we do understand that he was released to treatment on the 3rd, but we do not have confirmation of that he is still there. But for the record, we request an adjournment. I cannot represent where he is.
Bench warrant will issue on these cases for defendant's failure to appear, bond 10,000 cash surety. I will allow you at least some time to try to get some verification if he is in treatment. I won't have those warrants issue until September 16, 2025.
Thank you very much, Your Honor.
Thank you.
Thank you, Judge.
Court calls the case of the People versus Brandon Davis.
Trevor Mayville for the people, Your Honor.
Did you appear? Assistant Public Defender Ben Denowith on behalf of Mr. Davis, who stands to my right. Would you state your name for the record, sir?
Brandon Hezekiah Davis.
He's waiving.
Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Judge.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants is bound over to circuit court on a single count.
Able to stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
November 5th at 1:30 with Judge Conlon.
November 5th, 2025, 1:30 before Judge Conlon.
Thank you, Judge.
Bond continued.
Your Honor, may I be heard?
You want on bond?
No, just on the matters being called. We did call both of his case numbers, correct?
Mr. Davis?
Yes. Brandon Davis?
Do we have two Brandon Davis?
Both numbers are on the waiver form.
Yes, they're both, yes. So he's bound over on count one. They weren't banded together.
Thank you for the clarification.
Yeah, no, thank you for clearing that up because his other file is there. He's waiting on that one also.
Yes, Your Honor.
All right.
And I did want to clarify for the record that I had extended an offer to Mr. Davis that in exchange for a waiver, the people would not be filing a habitual offender notice against him in either file. He is going habitual 4, I believe, and so we're foregoing that. And I want to state that fact.
All right.
Thank you.
Thank you. All right, the other case also will be on that time before Judge Collins. All right. Thank you. Court calls case of the People versus Antonio Guyton.
Trevor Mayville for the people, Your Honor.
Assistant Public Defender Alexis Oakswood on behalf of Mr. Guyton.
Your name, sir?
Antonio Guyton.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
Cause conference, September 25th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Shaquanda Hall.
Public Defender Ben Denowith on behalf of Ms. Hall, who should be on Zoom.
Here.
Ms. Hall?
Yes, I'm here.
All right, you need a camera.
It's on.
No, it's not.
Okay, hold on. I'm trying. Okay.
Thank you.
Your Honor, we would like an exam date, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 23rd.
Yes, Your Honor.
Preliminary examination in person, September 23rd, 2025. What?
She was previously from a judge.
That's it, Barr. Yes. 9 a.m. before Judge Barr.
Thank you, Judge.
Bond continue. Court calls case of the people versus Jessica Hess.
Stephanie Cannon on behalf of Ms. Hess. Ms. Hess has been appearing by Zoom. Is she currently there, Your Honor? Maybe? No. or not? Okay. Then, Your Honor, at this time, we have reached out to my client. I even texted her. I have not heard from her. I would be asking for an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000. Cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court does call the case people versus Marcus Jones.
Josh Falls for the people.
Your Honor, Assistant Public Defender Natalie Pate stepping in for Ms. Perry on behalf of Ms. Jones or Mr. Jones. He is here, Your Honor. I just spoke with him in the hallway. Would you mind if I could go see if he's still out there or maybe in the bathroom? Or Ms. Cannon will grab him.
You're sending Cannon?
Yes.
Okay, I'll pass it.
Thank you very much,
It'll
Your
be a
Honor.
minute. Court calls the case people versus Jocelyn Mathis.
An Assistant Public Defender Natalie Pate with and on behalf of Ms. Mathis, who is present, not in the hallway. Could you please state your name for the record, ma'am?
Jocelyn Mathis.
All right.
Thank you, Your Honor. To my understanding, discovery is complete and I have reviewed it with my client. We're asking to set it for a preliminary examination at this time.
People had their witnesses available the 23rd.
Yes, sir.
Preliminary examination, September 23rd, 2025, 9 a.m. That is before Judge Freshour. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Kevin McCullough.
Josh Falls for the people.
Brian Bowling on behalf of Mr. McCullough. I'm hoping might be on Zoom.
He's not.
Your Honor, from all indications that I have, Mr. McCullough is at Bear River. Unfortunately, I was unable to get in touch with him to speak with him to confirm that, but that's my understanding. It is also my understanding there is a community corrections bench warrant outstanding on the matter already.
Yeah.
A prior hearing.
Well, I'll give you time to try to figure that out. I'll adjourn the probable cause conference because I also have the sheet from acknowledging admission. So it'll be September 30th, 2025 at 9.
Wonderful. Thank you, Your Honor.
And continue. Or the bench warrant outstanding. Court does call the case people versus Nathan McCullough. What is it? You got Joe.
Alexander on behalf of the people.
Assistant Public Defender Alexis Zerbs with and on behalf of Mr. McMullen, who is approaching. Once you get to the podium, please state your name for the record.
Nathan McMullen.
Thank you.
Your Honor, we do respectfully request this be set for preliminary examination.
Discovery is complete.
To my knowledge, yes, Your Honor.
Yeah. People have their witnesses available the 23rd.
We'll do our best.
Preliminary examination in person, September 23rd, 2025. 9 a.m. before Judge Barr. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the people versus Alexis Naveen.
Josh Falls for the people.
Oh, there she is.
And Public Defender Natalie Pate standing in for Ms. Lauren Kearney on behalf of Ms. Naveen, who is present via Zoom. Ma'am, can you please state your name for the court?
Alexis Naveen.
Thank you, Your Honor. I'm respectfully requesting an adjournment. The court should be in receipt of a green sheet. It is my understanding that we are requesting an adjournment to track progress in Veterans Treatment Court.
Yeah.
And Ms. Perny does need to speak to Ms. Naveen regarding an updated offer is my understanding, but I believe Ms. Phelps could probably correct me if any of that's incorrect.
Ms. Naveen, how you doing?
I'm doing quite well, Your Honor.
All right, good. All right, that's all correct.
It is, I had the opportunity to speak with Miss Burton Harris, I'm sorry, Chief Assistant Burton Harris this morning, and there's some other things that are sort of working in the background. Ms. Perry and I were also able to chat this morning, but I understand that we're gonna need an adjournment now.
All right. You want to go to the October date or you want?
I believe October would be sufficient, Your Honor.
Better, okay. So I'll adjourn this to October 9th, 2025, 9 a.m. or as your invite indicates, bond will continue. All right, thank you.
Thank you, Your Honor.
Take care, Ms. Naveen.
Thank you.
Court calls case People versus Nicola Nelson.
Good afternoon, Your Honor, Reagan for the people.
And Assistant Public Defender Ben Denowith on behalf of Mr. Nelson. I don't believe he's present, Your Honor, and he contacted our office this morning. He asked to
He's
appear. Is he on Zoom?
Sure. You can't see him because his camera's not on. Nicola Nelson. He's there. I'll pass it.
Thank you.
See if he pops in. Court does call the case of the People versus Cameron Nichols.
I should call this for the people.
Stephanie Cannon on behalf of Mr. Nichols, who is standing to my right. Mr. Nichols, could you please state your name for the record?
Cameron Nichols.
Thank you.
And Your Honor, I believe this is our first PCC. We're asking for an adjournment to see what we can work out here.
Probable cause conference, September 30th, 2025, 9 a.m. That's a Tuesday. Bound continued. Thank you. Court does call the case of the People versus Dimas Paz Madrid.
And is that on behalf of the people?
Assistant Public Defender Alexis Zerbs with on behalf, Mr. Paez Madrid, be present via Zoom.
Sir, can you state your name?
Dimas Paez.
All right.
Your Honor, we are requesting an adjournment to try to seek a global resolution amongst all of Mr. Paez Madrid's matters.
September 30th, 2025, 9 a.m. Bound continued.
Thank you, Your Honor.
Court does call the case of People versus Antonio Parker. You're all set, sir. Set. Did he? I don't know,
Well, I believe I was trying to request permit to go back to Indiana to my home.
Go where?
Your Honor, that's not
That-
my fault.
Hang on. I'll finish this.
Your Honor, my apologies, and Mr. Paez, my apologies as well. He did want me to request if he could have permission to leave the state of Michigan. He's originally from Indiana. His fiance and 2-year-old son reside in Indiana, and he's already spoke with community corrections that if he were to get that permission to live in Indiana, that they would be helpful in setting up his testing in Indiana, and then obviously sign that release to get the test results sent over to community corrections.
Your Honor, I would object. I believe he can be extradited from Indiana for these cases here.
Was he extradited?
Your Honor, I'm not sure of that fact.
Yeah, I did. I had an extradition from Indiana. I was brought here. I was released on bond, and right now I'm asking for permission to go back to my home to keep
For
working.
extradited to the state. If you extradite to the state, I'm not going to give you permission to leave.
And Your Honor, provided an extradition waiver was signed by our office. I do believe he was extradited from Indiana for these cases.
For these cases. He was extradited from Indiana for these cases. Motion to travel is denied.
But
Your Honor, thank you.
Well, sir, you know, you can keep with those faces. I don't think you want to do that. I've made my ruling. Turn your camera on. I gave my ruling. I gave the basis for that. If you've got a problem with that, the next hearing, and get those files in, will be in person. He needs to appear here. And then we'll see what faces you make.
no, I was not trying to make any faces. I was just like sad about it because I'm.
Court calls the
actually
case,
right-
People versus shut him off. Court calls the case, People versus Antonio Parker.
And then on behalf of the people, Your Honor.
Assistant Public Defender Ben Denowith on behalf of Mr. Parker, who is approaching the podium now. Mr. Parker, would you please state your name for the record?
Antonio Parker.
Thank you.
And Your Honor, we are asking for an exam date.
Discovery is complete. Discovery is complete.
Yes, discovery is complete.
People have their witnesses available the 23rd. Preliminary examination, September 23rd, 2025, 9 a.m. That's before Judge Freshour.
Right here in the 23rd.
Bond continued.
Thank you.
It is. Court calls the case of the People versus Glenn Pennington.
Assistant Public Defender Ben Dunaway on behalf of Mr. Pennington, who joins me at the podium now. Mr. Pennington, would you state your name for the record, please?
Glenn Pennington.
I have a plea form. Is that what we're doing?
Yes, we have a no contest resolution.
I have a plea form that indicates that the defendant will be pleading to use of a controlled substance. He'll be pleading no contest to that in count 3. That's a 1-year offense. Upon a successful plea to that charge, count 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
Defense agrees.
7 sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Yeah.
Yes, sir.
State your name.
Glenn Pennington.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of use of methamphetamine. That's what it's supposed to be.
Yes, sir.
Correct? All right. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes.
All right, 2 things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes, sir.
All right. Basis for the no contest plea?
Lack of memory.
And sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding those rights?
No, sir.
Please look at paragraph 5 on the form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
Court has been provided Chelsea Police Report Milan Police Report for their case number 234341. Any objection to the court having reviewed that report?
No. Oh, sorry.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, any sentence evaluation, the court would no longer be bound by any sentence evaluation or agreement. You understand that?
Yes.
And you also understand you could not withdraw your plea.
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be October 28, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Dorinda, is it Krasinski?
Good afternoon, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Krasinski. Will you state your name for the record?
Need to unmute, ma'am.
Can you hear me now?
Yes, we can hear you.
Okay, thank you.
Your Honor, first, we are asking for an adjournment of the probable cause conference for plea negotiations. I received notice that there's still an outstanding bond violation for her failing to report for testing. She is in treatment at Grace Centers of Hope. She's reporting from there now as well. She's been testing there. I received an update. I had some issues getting in contact with her this past week, but I received an update from her case manager today with a slew of test results that are all negative. I provided those to community corrections and to opposing counsel. I have directed her, we reached out to her caseworker today that she needs to sign releases. But I believe based on all that she is compliant, she is in treatment. We just need to kind of tie up those loose ends regarding.
I have a warrant out for her currently, don't
Ms. Pruzinski, do you have the information to call community corrections to sign over those release of information?
Yes, ma'am. I have community corrections, a phone number right here. Is that who I would contact, right?
Please call them immediately following this hearing, okay?
Okay, and yep,
There's the bank
absolutely.
warrant.
Thank you.
Bond denied because of this. All right. As the prosecutor, have you had an opportunity to look through all of that?
I have not, it's about 50 something on pages, and I just got it this morning, so I haven't had an opportunity to look through.
Apple gave you like 50 pages, said, look at this now.
I
That's what
can't
she
say
did.
look at
She,
it now.
no, she did say that, didn't she? And it was really demanding. Yes.
I'm so sorry. She appeared on 8/14. The bench bond was canceled. It's a $10,000 PR bond. This is an updated violation.
Got it. Okay.
Yes, I've been in treatment since the 2nd of July.
No, that's okay. We've got that, so I don't need to
Oh, I'm
deal
sorry.
with her. All right. Much time are you looking for?
If we could have a few weeks, I'm hoping based on, get some information and try to work out a plea
September
negotiation.
30th or October 9th?
October 9th.
And even
Thank you.
counsel, she took the
Thank
later
you, Your
date.
Honor.
Thank you. October 9th, 2025, 9 a.m. Where your invite indicates bond will continue. Thank you.
Thank you.
Court calls the case of the people versus John Riggs.
Brian Bowling on behalf of Mr. Riggs. Mr. Riggs, can you state your name for the record, please?
John Riggs.
Thank you.
Your Honor, I'm asking for an adjournment to allow him to continue to work with our mitigation department.
Just wanna, your signature.
September 30th. 2025, 9 a.m. Bound continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court calls the case of the people versus Kevin Riggs.
Good afternoon, Your Honor. Raymond Cook for the people.
Assistant Public Defender Alexis Zerbst with and on behalf of Mr. Riggs, who should be present via Zoom. Mr. Riggs, can you please turn on your camera, unmute, and state your name for the record?
Kevin Riggs.
This is Simpson.
Your Honor, we are requesting an adjournment. The people indicated that there was a newly authorized matter against him. That's not set for arraignment until November, so we were going to ask for about 4 weeks.
Excuse me?
The arraignment's not set until November. We were going to ask for about 3 to 4 weeks to see if we can get that pushed up so that we can work out these cases together.
It's a misdemeanor arraignment pretrial before Judge Trusher. I believe November 10th is the date that I saw on on my court.
You can get, I don't know if you're gonna get that pushed up, but that arraignment isn't until that date.
That's my understanding, Your Honor.
Crazy world. I'll just adjourn this to November 13th. 9 a.m. bound continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court calls the case people versus Jaleesa Robinson.
Assistant Public Defender Davy Lee on behalf of Ms. Robinson. Ms. Robinson, are you present?
Whoa,
Awesome.
he's right here.
Oh.
Why are you yelling over there? He's right here on my screen.
Excellent, Your Honor.
Ms. Robinson, can you state your name, please, for me?
Jaleesa Robinson.
See, I told you, she's right there.
I'm very glad to see that, Your Honor. I do have a green sheet. We're requesting an adjournment as I have not been able to have contact with Ms. Robinson, who I would ask to please contact the Public Defender's office as soon as possible.
All right, I'll adjourn it to September 30th, 2025, 9 a.m. Ma'am, do you have the Public Defender's office number?
No, sir.
All right. You ready?
Just 1 second.
You're not driving, are you?
No, sir, I'm parked.
Okay.
Sorry. Okay, I have a pen.
You got it? Okay,
Yes,
it's
sir.
area code 734-222-6970.
Okay, thank you.
Call them and make sure they have a good phone number and email address for you, okay?
Yes, sir.
All right, bond continued. Thank you.
Thank you, Your Honor.
Court calls case of the people versus Jesse Rogers.
Brian Bullock on behalf of Ms. Rogers, who's standing to my right. State your name on the record, please.
Jesse Rogers.
Your Honor, I'm asking for an adjournment, based on my discussion with Ms. Rogers earlier this week. She has some paperwork that my office needs to review, so we'd like the opportunity to be able to do that.
Probable cause will be adjourned to September 30th, 2025, 9 a.m.
Thanks, Judge.
Thank you.
Thank you. Okay. No. Court calls case, people, Jody Ann Russell.
Good afternoon, Your Honor.
Assistant Public Defender Alexis Zerps with and on behalf of Ms. Russell. Ms. Russell, can you please state your name for the record?
Jody and Russell.
Your Honor, we're respectfully requesting this be set for preliminary examination.
All discovery is complete.
To my knowledge, yes, Your Honor.
People have their witnesses available the 23rd.
Yes, Your Honor.
Preliminary examination in person, September 23rd, 2025, 9 a.m. That's before Judge Barr. Bond continued.
Thank you, Your Honor.
Court calls case, people versus Darren Sardiga.
Good afternoon, Your Honor.
Amy?
Assistant Public Defender Chelsea Vergils with and on behalf of Darren Sardiga. Mr. Sardiga, please state your name.
Darren Sardiga.
Requesting an adjournment.
To continue our plea discussion.
Probable cause conference, September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Jeremy Schultz.
And Assistant Public Defender Natalie Pat standing in for Public Defender Lauren Perny on behalf of Mr. Schultz, who stands to my right. Please state your name, sir.
Jeremy Schultz.
Okay.
Thank you, Your Honor. As to the PCC, I'm respectfully requesting for an adjournment. Ms. Perny advises that we seem to be missing some discovery, a photo lineup, and we do not have that photo array. So we'd be asking for an adjournment.
I have a violation report. Has he gone over to community corrections at all?
I can address that, Your Honor. So
Yes.
it's my understanding that he was released from Washtenaw County Jail and then transferred directly to Wayne County Jail, where he was then incarcerated for 2 months. Lauren Perny advises that she did speak with his probation officer in Wayne County via telephone to confirm this. and did send her written confirmation, which I do not have right now today, that Mr. Schultz is testing with them on probation also, and that he last tested on August 18th and it came back negative, and he is attending AA. He states to me that he is willing to test today, asking for the court to allow him to go test and that he would come back clean. He just advises that when he was transferred to Wayne County, he was not told that he needed to re-enroll with community corrections.
Well, he needs to go over and re-enroll and test at community corrections.
No problem.
We'll need a new order. And I'll adjourn the probable cause. That's what you're requesting.
Sorry, Your Honor.
I'll adjourn this to the 25th, 2025, 9 a.m.
Thank you, Your Honor.
Ron, we'll be preparing a new order. He needs to go over there now.
Thank you, Your Honor. And my client is asking if he should return to court after he tests today.
No, you're dirty. Just to have your affairs in order when you show up on the 25th.
I have to do a hair today for a job interview, so I'm not worried.
Thank you.
Thank you, Your Honor. He'll head
Thank
over
you.
there right now. Thank you.
Get 2 cases.
Yes, okay.
Court does call the case People versus Diana Seaborn.
That's close to people, just the one.
Yeah.
And Public Defender Ben Dunaway on behalf of Ms. Seabrook, who stands to my right. Would you state your name for the record, please?
Diana Seaborn.
All right.
Your Honor, we would like an exam date, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 23rd.
I'm just checking, I'm just getting in. Double check real quick. We'll try for that day, thank you.
All right. Washtenaw State of Michigan, combat exception, the Honorable Judge Jason.
You may be seated. Recall the case of the People versus South.
Mr. Public Defender Docket, leave before Ms. South is approaching from my right. Ms. South, can you state your name?
Myra South.
What the court has decided to do, given the responses.
Your Honor, could we approach for a moment?
I don't know that there's anything you can say that's gonna let
Not yet.
approach.
I may approach. Thank you.
Record should reflect we had a bench conference in this case, and given the responses from the defendant, the court is going to choose on its own. Understanding that counsel has given me an explanation that I'm not going to take the defendant's plea today. I will adjourn the probable cause conference to my next available date, which will be September 25th, 2025, 90. Or right in, her bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Jordan McKinney.
I always said on behalf of people.
David I. Goldstein appearing on behalf of the defendant.
Her name?
Jordan McKinney.
Thank you.
Your Honor, we have requested an adjournment in this matter. I still have not received a discovery from the people. I did discuss it. And I know it's coming, but we have not received it yet.
All right.
So I'm asking for a 1-week adjournment, if that's okay with the court.
1 week. Is the discovery on its way or?
Yes, Your Honor, it should be.
Okay.
I believe it was sent to previous counsel and then it's making its way.
Gotcha. All right, probable cause conference will be adjourned September 18th, 2025, 9 a.m.
I would like to address the court on the issue of bond, and I did indicate that I was going to. Your Honor, just very, very briefly, I understand that the bond in this case is $35,000 cash or surety. I understand the charges against my client. My client does not have any other pending cases. He is not on probation or parole. If he were allowed to post bond in this matter, he would be living in Westland with his mother. The complainant in this matter, I assume, lives in Washtenaw County because it's a city of Ann Arbor case. The court can deal with the issue of protection of the complainant with the conditions and a GPS tether. But given the lack of any significant criminal history, I couldn't find anything in Washtenaw County. There was something that might have happened in Ohio when he was in school approximately 10 years ago. But I can't find anything in this county more recent than that. So I'm asking for a reduction, Your Honor.
Your Honor, at this point, I would be objecting. The facts of this case are that the defendant was driving with the victim and her children, and the victim was becoming uncomfortable and wanted to leave with the children and take a bus rather than be with the defendant. He would not let her out of the car and continued speeding down the road. While he was driving, he punched her in the face with a closed fist and wouldn't let her or the children get out of the car. They eventually approached his Olga's and she tried to get out. There was videos of her from bystanders showing her trying to leave the vehicle, and he would speed forward. Eventually, she was pushed from the vehicle by him, and her older child was able to get out of the car. The victim then tried to get the younger child, an infant, from the car, but was unable to after he sped off with the infant child's door still open on the vehicle. So at this point, I would be objecting to any modification of bond at this point, given the facts of this case.
Well, Your Honor, there are no facts of the case. There are allegations, which have not yet been even to a standard of probable cause been proven. So I would indicate, just based on the charges and my client's lack of any significant criminal history, that $35,000 is not reasonable.
Well, given the circumstances as at least explained, and certainly maybe at some point there'll be a different version of that, but given those circumstances, the court would consider a defendant a risk to the public and would deny the motion for bond reduction. Court finds that bond is appropriately set.
Thank you, Your Honor. As soon as I get the police report.
So it's bond.
Hopefully this week.
Thank you. Court calls case of the People versus Adrian Braswell.
Trevor, may I help with the people?
Good morning, Your Honor. Chris Sestope on behalf of Adrian Braswell, who should be appearing via Zoom. Now. Individual whose iPhone 1. That's him. Yes. Your name, sir?
Adrian Braswell.
Your Honor, here and I approach really quick. Oh, I promise it will be quick. Okay. Thank you.
All right, record should reflect the bench conference in this case. I will adjourn the probable cause conference in this case to October 9th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Mr. Braswell, I'll be in touch with you soon.
All right. Thank you, Mr. Braswell. Court does call the case of the People versus Dwayne Stevenson.
Emily said on behalf of the people.
David I. Goldstein appearing on behalf of the defendant. Mr. Stevenson, state your name, please.
Dwayne Stevenson.
You're on the same situation in this case. The discovery in this matter is bouncing around about 3 different attorneys because the public defender was appointed. They had a conflict out. Then Mr. Drukas was appointed. Somewhere in the blogosphere, the discovery is coming. I believe that I received his about 2 minutes ago, but I haven't had a chance to check.
So this defendant?
This defendant, not Mr. McKinney, this defendant.
Gotcha. Okay, so you want an adjournment?
Yeah, again, 1 week, Your Honor. And I do want to address bond in a moment when the court's ready.
You can be part of 150 cases. September 18th, 2025, 9 a.m.
I'm used to that, Judge, you know. Judge, just on its face, my client's bond is $500,000. I think on its face, I mean, that's a bond you usually get in a murder case, or not a murder, but an assault with intent to commit murder, a CSC1, an armed robbery, something of that nature. My client is not on paper of any kind. I do acknowledge that he does have a prior criminal history, but his most serious charge was 2008, I believe it was, which is 17 years ago. He came out of prison on that in 2015. He successfully completed his parole. He's had one minor brush with the law since that time. And he would be living with his mother in Ann Arbor. And again, the court can set conditions, including GPS tether, that would protect the public and the complainant in this matter.
Your Honor, I would object to any modification of bond. I believe in this case, I originally requested a bond of $1 million, and we were given a $500,000 cash surety. Mr. Stevenson has a previous history of 28, few cases prior to 2016 OWI, 2018 attempt RNO, 2018 pre-attempt RNOs, 21 receiving concealed under 200, 2020 dismissed GBH and DB, 24 RNO, and a 24 DB conviction. I expect that this does go to exam. It could potentially, an AWIP could be added, as well as he could be made a habitual fourth violent offender. In this case, the victim reported 3 different distinct assaults in which they involved Mr. Stevenson punching her multiple times, kicking her, strangling her to the point of unconsciousness. The victim went to see her mother. Her mother observed her to be limping with broken teeth, lacerations to her lip. She went to the doctors and found that she also had a broken rib. The assaults kind of follow the same pattern of strangling, punching, kicking, dragging her up the stairs by her hair, fracturing her rib, punching her so hard in her ear she has hearing loss. He also sent her texts that say things like, I wish you would have died when I put my hands on you for real. I wish you would have just died on the floor and I would have kicked you. Y'all played with my time. I should have killed both of y'all. Answer the effing phone. You don't know where my shit at. Open the door or I will shoot. And on a voicemail that I listened to, given to us by the victim from the defendant, he says, I know you called the police, so I will kill you before you get any chance. I mean, I have concerns for not only her safety, but the fact that he has this violent criminal history of RNOs as well, that he's a danger to the community, and then he could and maybe will kill her if he is let out. I have great concerns for her safety. And I believe that a $500,000 cash surety bond is appropriate, even though we did request a $1 million bond, given the facts of this case and the allegations.
Well, again, Your Honor, she did say allegations, and that part I can accept. They are not facts. They're not facts until they're proven. And, you know, Your Honor, I'm not going to justify my client's prior history, except to say with regard to those RNOs that have occurred since he was out of custody and out of parole, he doesn't like police, but she's not a police officer. So.
And Your Honor, I did want to put, he was in prison in 2009 for armed robbery and home invasion 1.
Right, that's what I said, right.
Even though the court does consider the defendant to be a danger to the community, I don't believe that he's necessarily a risk of flight, but certainly a danger to the community, especially if the allegations are true regarding the shooting and or killing of an individual after these circumstances. The court would therefore deny the defendant's request for a bond reduction. Bond would remain the same.
I'll be with you this weekend once I get the discovery, okay?
Thank you. Court calls case People versus Adam Allen.
Good afternoon, Your Honor. Raymond Cook for the people.
Deborah Schlossel on behalf of the defendant, Mr. Allen. Your Honor, I don't know what happened to my client. He texted me this morning. I thought he was going to be here. I just called him.
So he's a no-show like his drug test. I mean, I'm sorry. Go ahead.
Well, he tried to rectify that, I believe, this morning or yesterday. I thought maybe he got arrested by the court. Is that possible that he might be somewhere?
Possible. Did we? Oh, where's he?
I'm right here.
Oh, did we issue a warrant? Yes, I think we did. Well, no, I got a recall.
We issued an order to comply just last week on Friday.
Right.
So no warrant.
No warrant as of yet.
So, Your Honor, he told me that he went in to get everything resolved either yesterday or today, and he texted me. I told him that the hearing today was at 3 and not 9 a.m., which, you know, people get the notice that says that. He said, okay, he was planning to be here. I don't know what happened. I called him, I've texted him, and he's not here. I have not received a response. Your Honor, I think something probably is wrong. I know you're not going to grant this, but I have to ask anyway. I would ask that either I be allowed to waive my client's presence or that this matter be adjourned out a week or two so that my client would have a chance to show up.
Bench warrant will issue for defendant's failure to appear. Bond will be set at $25,000 cash surety. That warrant will issue immediately. And certainly you can do a warrant recall if he has justification for not appearing.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Raul Fernando.
Good afternoon, Judge. Good to see you. Aida Spahich on behalf of Mr. Raul Fernando, who is present via Zoom. Judge, thank you for allowing my client to appear via Zoom.
Sir, can you state your name?
Raul Fernando.
Thank you, Judge. Today is the date and time set for a PCC. I am respectfully requesting a 2-week adjournment if at all possible. I did receive and review the written discovery. I did receive this week video discovery. This week was a bit hectic. I just needed a little bit more time to review everything and sit down with my client and review it as well, Judge. So I'm just respectfully requesting.
I appreciate the candor.
It's usually I'm very good. Just
Yeah.
downloading can take sometimes hours depending on the Wi-Fi, and it's just it's just been a little bit hectic the last 2 days, Judge. So I respectfully need the time.
I understood. So
Thank you.
without objection, I will adjourn this to September 25th, 2025, 9 a.m.
Thank you, Judge. Thank you so much for your time. Have a wonderful day.
You do the same. Court calls the case of the People versus Joseph Spittler.
Good afternoon, Judge Lawrence H. Margolis with and on behalf of Mr. Spittler, who is present with me via Zoom. Mr. Spittler, please state your name.
Joseph Spittler.
Thank you. All right, what are we doing?
Judge, today's the date and time set for PCC. I've talked to Mr. Kennedy. He was going to ask for a little time. We're working on a resolution that requires the parties to seek more time. And Mr. Kennedy is not here, so I'm feeling okay that I can make it on his behalf, but I will defer to Ms. Londi as well.
Well, that's not her name, but go ahead.
Oh, I didn't hear, sorry.
That's my understanding is we're looking for 2 to 3 weeks, Your Honor.
All right. Probable cause conference, September 30th, 2025, 9 a.m. Bond continued.
Thank you, Judge. Have a good day.
Thank you. You too. Court calls case People versus Justin Robinson.
Good afternoon, Your Honor. Wendy Barnwell, P42-505, on behalf of Mr. Robinson.
Her name?
Justin Robinson.
Thank you. Where are the rest of your pants?
Your Honor, I was in the rest because I had to take the bus here. I don't have reliable transportation. I'm a 24/7 dad, so I just wanted to make sure I got here.
No, I got you. Just next time wear long pants. Please.
Okay.
Go ahead.
Your Honor, we're respectfully requesting an exam date.
All right. Discovery is complete, counsel.
Yes.
And would the people have with their witnesses available on the 23rd?
Not available on the 23rd, Judge.
This would be easy. No, go ahead.
Sorry.
Then we would have the 30th.
I believe I'm available. Yes, I'm available.
All right. Any objection from the people to that date? Preliminary examination in person, September 30th, 2025, 9 a.m. before Judge Washington.
That's in this building, correct, Judge?
Oh, yes.
All right.
It all happens here. Bond will continue. Thank you.
Thank you. That's it for me.
Court calls the case. People versus Anthony Alfaro Callejas.
Representative of the people?
Good afternoon, Your Honor. Attorney Zach Bonham on behalf of the defendant who's joining me at the podium now.
Good afternoon, Judge.
What are we doing?
So today, Your Honor, we'll be asking for an adjournment of the PCC. We have one piece of discovery that's outstanding that we need to have, and I believe we'll have that very shortly. The other thing, I'd like to address bond when we're done with that.
There's supposed to be a hearing on this bond violation.
Correct. Well, there's also PCC and a bond violation hearing.
I know, I said it.
Okay. For the bond violation, my client would be admitting responsibility to the bond violations. I believe a week would be sufficient, Your Honor. Oh, okay.
We need more than a week. I checked, there's a video that was taken by a witness, that the defense counsel was looking for. I checked, it's not something that we have. It appears that officers just looked at it, and it's the phone that it's on, briefly seen in the body cam. But it is not here in the report that the police actually took it from that witness. I did email the listing OIC to get us that video. He said that he is no longer the OIC. He is for the new OIC. But we need more than a week because someone has to go out there and get that video.
Understood.
All right, well, you think they'd be able to do that in 2 weeks' time? Or is it gonna take longer? I mean, obviously there are things you can't know, like the person that has the phone, how cooperative they're gonna be or anything else, but.
Your Honor, I mean, I think it should be able to be done in 2 weeks. I just don't know that it's likely to be done in 2 weeks.
All right. Here's what I'll do. Won't quite go 3 weeks. I'll set it for September 30th.
That's good, Your Honor.
All right. At 9, I'll set it at 9 at this time. All right, as to bond.
Your Honor, I spoke with the prosecutor about how to address bond in the situation. Before my client was incarcerated last week, he had been on home confinement. Speaking with the prosecutor's office, they would agree that home confinement would be appropriate for my client. However, we'd be asking for a scram tether rather than the sober link. As what brought us here for the bond violations is my client, in part, saying that he was testing inaccurately. He thought he was supposed to be doing one way, it was supposed to be another way. Let's take that out of the equation. Let's put him on a scram tether so we'll know right away whether there's a violation.
Take his lie out of the equation.
His
No, you don't need to respond.
Thank you, I
That's just
appreciate that.
All right.
So we'd ask that he be back on the scram tether, well, go onto the scram tether rather than sober link. And if the court is willing to place him back on home confinement, prior to the last PCC, I submitted a proposed amended bond order. My client has a new apartment that he had just rented. We'd ask that home confinement be at the new apartment, along with the other conditions that we had, that he be allowed to leave the residence for work, medical appointments, a court hearing, limited exceptions. And I guess the last thing I would mention, that he still has his job at Los Amigos. He said he was making close to $6,000 a month working there, but because of the situation that he placed himself into, he still has a job available. It is with reduced hours, so he can still make roughly $2,000 a month, but the job is still there.
Here's what I'll do. Well, on his bond violation, I'll sentence him to 7 days credit for the 7 days that he served. And then I will reinstate his previous bond with home confinement and a scram tether. Both of those must be fitted prior to his release.
And that's at the new address, Your Honor?
Yes, that they will get an address from him, so he's got to make sure to have that address.
I'll make sure that he does. I just want to make sure that there'd at least be a record that it would be for his new apartment. So do you have the address? Yes, I do, yeah. Can you tell the judge what your address?
Well, no, I don't want it on the record. He can give it to you.
Never mind, Your Honor. Don't need to do that.
And we'll make sure that those orders are entered.
I also have a green sheet if the court would like it.
Yes.
Thank you.
All right, we're all set. Thank you.
Thank you, Your Honor.
You need this.
Yeah. we just-
Is that it for us? 14A stands adjourned.